Good morning and welcome. I'm Councillor Legg, Chair of the Standards Committee, and welcome to this meeting of the Standards Subcommittee. I will ask everyone to present themselves shortly first, but I will address some housekeeping. This meeting is not being live streamed, but is being recorded. The subcommittee will need to determine whether the public and press will be excluded from all or any part of the hearing. If any part of the meeting remains public, the recording of this section will be posted on the Council's YouTube channel as soon as possible after the meeting. When addressing the meeting, please use the microphone in front of you so you are audible in the recording. We're not expecting a fire alarm today, so in the event the alarm sounds, please exit the building by the nearest marked exit and assemble outside as indicated by officers. Everyone in attendance today should have received a copy of the papers. The public papers for the meeting are also available on the Council's Modern Gov Committee Management website. Following the committee's decision on whether to exclude the press and public, should any documents be made public, these will also be published on the Modern Gov website. I appreciate that the subject of this meeting is one which could be emotive, and we will endeavour to keep this in mind throughout the meeting. I would ask that everyone present treats each other in a respectful manner, and as chair, I will step in if I need to remind anyone of this. I do have the discretion to withdraw a person's permission to take part in the hearing, but I hope this will not be necessary. The first order of the business is to elect a chair. As outlined in the Milton Keynes City Council Standards Committee hearing procedure, as the chair of Standards Committee, I will also be chairing the Standards Subcommittee today. Item 1A is apologies and disclosures of interest. Sian, have we received any apologies?
Thank you, Chair. No apologies received.
Councillors are to declare any disclosable pecuniary interests, other registrable interests or non-registrable interests, including other pecuniary interests they may have in the case. Should any councillors have any such interest, they will need to withdraw from consideration of the case. I will remind members that they would not be considered to have a non-registrable interest simply because they belong to the same political group as the subject member. So item 1B is to confirm the meeting is quorum. Oh, sorry, jumping ahead. Are there any interests to be disclosed? No. Thank you. Item 1B is to confirm the meeting is quorum. Sian, could you confirm this is the case?
Thank you, Chair. Yes, I can confirm that the meeting is indeed quorum.
I will now ask everyone present to introduce themselves, beginning with the members of the subcommittee. So, as I've said, I'm the chair of the subcommittee, Councillor Mandy Legg.
I am Councillor Aisha Kanom, a member of the subcommittee. Thank you.
Councillor Selina Raja, Vice Chair of the Standards Committee and a member of this subcommittee.
Now of the subject member. Oh, sorry. Sorry.
Good morning, I'm Parish Councillor Richard Pryor. I'm a parish representative on this subcommittee, and as such, I am a non-voting member of the subcommittee.
Thank you. And now, if the subject member, if you could introduce yourself, please.
Yeah, morning everyone. My name is Taime Bungupachi and I'm a local parish councillor for Council and Moncton. Thank you.
Thank you. Would you like to introduce your person?
You want to introduce?
I am Dr. Tamara Shingelia. I am representing Daimler in today's proceedings. I am a trained trade union representative and caseworker.
Just to confirm in advance, Tamer said you were representing yourself and bringing your support member with you? Yes, yeah,
Yes, that's correct. Yes.
thank you. Followed by the independent person.
Good morning. My name is Chris Fogden. I'm one of the independent persons appointed by Milton Keynes City Council and have been invited to this meeting today to give my views.
Thank you, Chris. And the investigating officer.
Good morning. I'm Simon Gocher. I'm a solicitor at Waitmans LLP, and I'm the investigating officer in this case.
Thank you. So the complainant is next, please.
Thank you. My name's Daniel Hippie. I'm here as a member of public and a complainant.
Thank you.
Hi, I'm Tiffany Chung, and I'm a trainee solicitor here at MKCC.
Thank you. And finally, the officers, beginning with the monitoring officer, who will be acting as the subcommittee's legal advisor.
Good morning, everyone. My name is Sharon Bajrad Singh, and I'm the Director of Law and Governance.
Morning all, Sian Lloyd, Senior Democracy Officer and Clerk to the Standards Committee.
Good morning all, Peter Brown, Head of Democratic Services, MKCC.
Thank you. So just before we start, I'd just like to ask if everyone is happy if we use first names today throughout the procedure.
Yes, we are.
Yeah, thank you. Before we go to the remainder of the agenda, I think it would be helpful to set out the procedure for today. So firstly, I would like to remind the subcommittee that the purpose of today's meeting is solely to make a determination on the findings of fact, whether the subject member has breached the code of conduct and appropriate sanctions, and not to comment on wider governance of parish council proceedings. Although this is a formal meeting, it is not judicial and evidence is not given under oath. The standard of proof to be met is on the balance of probabilities, as in civil proceedings, and not beyond all reasonable doubt, as in criminal proceedings. I would also like to confirm that throughout the meeting today, we will be following the procedure set out in Milton Keynes City Council Standards Committee hearing procedure, with revisions adopted by the Standards Committee on the 28th of January 2025. All parties will have received a copy of this procedure, page 647 to 664 in the agenda pack. In summary, there are 3 stages to the procedure for today's meeting. 1 is the findings of fact. 2, has the subject member breached the code of conduct? And if it is found that the subject member has breached the code of conduct, what sanction, if any, is appropriate? As stated in the hearings procedure, as chair, I may agree to vary this procedure where I am of the opinion that such a variation is necessary in the interests of fairness. Please can I ask if anyone has any questions about the procedure before we continue? Thank you. So, exclusion of press and public. At this stage in the procedure, we must now consider whether the press and public will be excluded from the subcommittee hearing. The subcommittee has the discretion to exclude the public if it considers that exempt information is likely to be revealed during the hearing, but must also consider its duties to act fairly and within the rules of natural justice and promote public confidence in the integrity and honesty of public authorities. So please can I ask the subject member, the investigator and the monitoring officer whether they wish to ask the subcommittee to exclude the press or public from all or any part of the hearing, and if so, their reasons for requesting this.
We got no reason to exclude any member of the public. We fine. Yeah.
Thank you. Simon would like to speak.
Just briefly, I mean, it's obviously a matter for you, and there is a strong presumption that these matters will be transparent and heard in public. The only one thing I would say is that to the extent that the subject member may wish to raise issues, as he has done in some of his correspondence and documents that he's placed with you, potential issues relating to disciplinary action against a former employee of the parish council, that's not something that normally would be aired in public. It's a limited amount of information about that in the documentation before you. I'm conscious that that person isn't here today, and I don't know if he's had an opportunity to make any comments about that. But I do think the council needs to be wary of, and it's difficult to say at this stage of the process, an extent to which that evidence is explored or gone into, whether it is right or fair to that individual that information be made public. Subject to that, my view would be that these proceedings normally are best heard in public, but normally where there's information about an employee, and particularly about any potential disciplinary action against them, that isn't something that would be discussed in a public hearing.
Thank you, Simon. No, ask Sharon to speak.
So just to endorse what Simon said, there's a strong presumption that these matters are heard in public, and that would be my advice to the committee. But insofar as a category of information, that is information relating to a person and their employment and any disciplinary hearings, my advice to the committee is also that one, I would question the relevance of it, and as we go along. And two, if that does become relevant, then we will need to consider whether we deal with that privately. But if I can ask the subject member to bear that in mind as you go along, that matters relating to an individual's employment, past employment, or disciplinary hearings are not matters for public session. And if you would like to raise them, then you would probably need to start by addressing the committee on their relevance.
Yeah, just to inform you, I do think that anything related to the workers, if it's relevant for this case to defend myself, I will wish that be discussed in the public.
Sorry, could you just repeat that, Tamer? I didn't quite.
So what I'm saying is, if I think that is relevant for me and for the case, for my own defense, I will suggest that any matter related to that particular ex-employee to be discussed.
That condition acceptable? Was that not relevant to the proceedings today?
So I think the position, to mirror the position we're saying, is that any matters relating to an individual's employment or disciplinary hearings should not be heard in public. If you think it's relevant to your position, then can we ask you to make that clear before you do that? And then in the event that the committee decides to go public, then they can treat that as a private matter, and we can consider how we deal with that. But we would not want those matters to be aired in public.
Yeah, I just feel that if it's public, so I really don't understand why certain matters won't be able to be discussed. So in that case, Sharon, at the first place, that hearing shouldn't be public at the first place. If you decided that this hearing going to be public, and then why you going to decide to exclude certain discussion from the public? So that's where I'm getting a bit confused.
Okay, so it's a matter of law. What can be defined as confidential or exempt information, and generally, that law is set out in the Local Government Act 1972, Section 12A, and generally matters relating to an individual, and particularly employment and disciplinary proceedings, is something that we would treat as exempt. I think I have a way through. Chair, is that okay? In the event that the committee would like the matters to be heard in public, then your resolution can be to do that, subject to any discussion relating to the employment of any parish council officers we can deal with as private within a public session. So to me, what that means is that you will still have the ability to raise it, but when we do so, that those parts of the proceedings would be treated as private, so redacted. And
so Sharon, the fairness of this procedure, I don't understand. Why did you then deciding that this hearing going to be public, knowing this fact? You shouldn't be letting everyone to be attending the meeting, is it?
we're talking about one category of information within a wider category of information, a lot of information. So we're just saying in respect to someone's personal information, that should be kept privately. The rest of it, my advice to the public, to the committee, as you've heard me say earlier, is that it can be heard in public.
Sorry, I still don't understand. So, because that person was a complainer as well, even if it's no longer part of the parish council, but it was part of the complainer as well. So I don't understand why, if you decided that this hearing going to be public, and then when it's come to discuss this particular issue, you decided that need to go private. I don't see how fair is it.
So first of all, no decision has been made yet by the committee. The committee is taking advice now on this point. So the decision about whether it's heard publicly or not is a matter for the committee to vote on, and I'm sure they'll do so shortly. What they're doing now is receiving advice on making their decision.
Thank you, Sharon. So we're going to vote now on whether the session should be held in private or in public.
So, Chair, just as a work, just to take into account the points, in the event that the committee would like to hear the matter in public, then it could be subject to any discussion relating to parish council officers, and their employment remains private.
Yes. So we're going to vote on public, as Sharon said, that if anything comes relative to a parish council employee, it remains in private and is redacted. And we have votes for proceeding in public, please.
For public. For as well. Thank you.
For public for myself as well. So we will be going forward in public, and if there is any evidence that needs to be removed, redacted, that will take place. So we now move on to the presentation of the Monitoring Officer's report. Sharon, please can you present the report?
Thank you, Chair. In the interest of expediency and getting on with the hearing, I'm going to take the report as read. There's just one update that I'd like to bring to the committee's attention, which is in relation to paragraph 2.6, when we said to the committee that we would be referring the matter of the registration of disclosable pecuniary interest to the police. We've had a reply from the police, and it is this: the bar of culpability in circumstances is rather high for this type of offence. Therefore, this is not something that the police would be involved in. So that closes off paragraph 2.6 in relation to the police's
involvement. And then just to remind the committee of where we are in our procedure for Code of Conduct complaints, to remind you that we have had 2 decision points up until now. The first at initial assessment, where I made a decision to move to investigation, a decision that I did not take lightly and never take lightly in respect of Code of Conduct complaints. And then secondly, at the outcome of the investigation, there was an opportunity to make another decision. The preferred approach in all Code of Conduct complaints, as set out in our procedure, is for informal resolution, but we weren't able to secure that, hence us moving to hearing. And then finally, just to confirm to all present that we conducted a thorough pre-hearing process with the chair and the committee before today's hearing. Thank you, Chair.
Simon, perhaps you'd explain your qualification in terms of being the investigative officer as well.
Of course. As I mentioned, I'm a solicitor. I'm a partner in Waitmans, which is a national law firm. I'm head of local government at Waitmans. I've been in that role now for the past 13 years. Prior to that, I worked in local government for nearly 20 years. I qualified as a solicitor, gosh, in 1996, so 30 years ago. When I was last in local government, I was a monitoring officer for about 6 years. I carry out standards investigations for local authorities up and down the country, and have done hundreds of them. So I would say it's probably the biggest area of my legal practice is carrying out standards investigations or advising councils on standards matters.
Thank you, Simon. Thank you, Sharon. So can I ask the subject member if he has any other disagreements with the finding of facts that haven't been covered in the monitoring officer's report? If there is anything, I would be grateful if you could also explain why these points weren't identified as part of the pre-hearing process.
Chair, so I've got a list of questions I would like to raise and ask to the, as I've previously asked to the monitor officer. I've got a bank of questions I would like to ask regarding the finding fact to the investigator. Is it the right time to ask, or do you think I should be wait my time will be allocated?
Yes, that's for later on.
Okay.
So we're purely asking you if you are coming up with any disagreements to the finding of facts that haven't been already covered by your response to the
yes, I do.
You have some more.
Yeah.
And you also need to be very clear in explaining why these points weren't identified as part of the pre-hearing process at the time when you were given the opportunity to raise those things.
Okay, thank you.
So we're looking at things that might be new things coming in at this stage that you had no access to. That's what we're looking for at this stage in terms of your disagreement with those.
Right, okay. Okay. Yeah, Chair, I didn't have enough time to be honest, to go through all the document that has been provided. We have quite a few email correspondence between the monitor officer and I when I requested some audios and some document. So I found out that the first one, the document that has been provided to me, wasn't totally all the document I did receive when I requested more document. So the first document I received from the monitor officer, and then I asked the monitor officer whether I have access to all the document that the investigator has, and then they sent me more document. So finally, I didn't have enough time to go through already, but yeah, I just prepared a bank of questions that I would like to ask.
So that will come in the next stage. Yeah.
Okay.
Thank you.
Thank you.
So the subcommittee is now asked to endorse the pre-hearing directions. Is this agreed? Agreed. So now we've completed the initial items, we move to the first stage of the procedure, which is the findings of fact. In this section, we are establishing what the facts are on the balance of probabilities. We will hear first from the investigating officer and any witnesses they may wish to call, followed by the subject member and any witnesses they wish to call before both parties have an opportunity to sum up the main points of their argument. At any point through the process, the subcommittee may question anyone present, and both the subject member and the investigating officer will have the opportunity to challenge evidence put forward by the other party and their witnesses. Following this, the subcommittee will retire to make a determination on the finding of fact. Please would the investigating officer make their representation as to the findings of fact.
Thank you. Well, as as the monitoring officer's done, I'll assume you've had an opportunity to read my report. So I'll just try and highlight the key elements and also the response that the subject member has put in where he has identified the facts that he disputes. As you'll be aware, there were 2 complaints which I was asked to investigate, which had a number of different elements to them. The complainants at the time were an employee of the parish council and a councillor, although my understanding is that they are no longer an employee or councillor of the parish council in question. I've summarised the allegations made in the complaints at paragraph 3 of my report, and I make reference to page numbers. It's always difficult in these cases because my report has page numbers on them, and then your system puts additional page numbers on them. So I will refer to the page numbers on your system, which are in the bottom right hand corner, and hopefully that will assist you. Effectively, there were a number of elements of the complaint that I didn't find proved or that I found not to be a breach of the code, and I won't trouble you with those because I think we've got plenty to get through. It is, and hopefully that will be accepted. In relation to the findings of fact, which I did then at the next stage, you'll have to consider find that they amounted to a breach of the code. They can be divided into 3 categories, essentially. The first one relates to the failure to declare an interest on the Register of Interests form, which has been referred to the police, which, as you've heard, the police have indicated they're not going to prosecute, but nevertheless, even though there's no prosecution, that still amounts to a breach of the code, which in my submission you would need to consider. There are then emails which the subject member sent to the former clerk or to others in relation to the former clerk's behaviour and conduct. And the third category is the subject member's behaviour at a number of parish council meetings. Now, the findings that I made in relation to those elements are set out in paragraphs 162 to 178 of my report, which is at pages 81 to 85. I will go through them briefly, but it seems to me if you look at the subject member's matters of dispute that he puts forward to you, he doesn't actually really dispute the essential fact of most of those elements. What he seeks to do is argue that they need to be seen in a wider context. He seeks to excuse or justify them, or he seeks to suggest that my findings that they actually amounted to a breach of the code were wrong, rather than they didn't happen. And in a sense, that's inevitable, because if you look at the nature of the facts, one relates to a form which wasn't filled in correctly, and there's no denial that it wasn't filled in correctly. The second category relates to a number of emails which he accepts that he sent and which you have and speak for themselves. And in relation to the behaviour in meetings, the vast majority of those were recorded either on audio or video or both. And I appreciate I only have 15 minutes, so we can't go through, you can't have the pleasure that I had of sitting through several hours of listening to parish council meetings as part of this investigation, but I have identified some which I think as a representative sample indicate the sorts of behaviour that was engaged in, and which in my view speaks for itself. So in terms of disputes on facts, I don't really think essentially there are. It's more about contextualization. So I'm not sure in the sense of this part of your process whether there is that much for you to consider, or whether the bulk of that is in the next stage, which is in acting as he did, whether the councillor breached the code. But I will try to quickly just go through the findings to contextualize that. Paragraph 164 of my report, which relates to the failure of the subject member to declare his employment on his register of interest forms. As I say, he accepted that at the time that he filled that form, he worked for Tesco's. He didn't include that in the section which requires him to complete the occupation, and that form, if you wish to look at it, is at page 381 to 383 and was completed on the 1st of August 2024. In his evidence to me, he stated that he was still working for Tesco at the time he completed that form, but he did not include it on the form. He had previously, on the 1st of April 2024, when he completed the form, included his employment with Tesco. He says in his response, which is at page 555, or his disputed fact, he did not deliberately fail to include it. Well, that's not necessary for there to be a breach of the code, that it's a deliberate concealment. He doesn't explain why he didn't include it, other than trying to blame the former clerk for not picking up on his error. But one, it's his responsibility to fill the form in and fill the form in correctly. He didn't do that. Therefore, he has failed to comply with the requirements of the code. If he has any excuse, he hasn't provided any, other than, I've said, trying to blame the former clerk and saying it wasn't deliberate. But even if he has, that goes to mitigation, not to whether or not he's breached the code. So that's that one. Paragraph 165, which relates to the meeting of the 11th of March. Again, he states that he disputes these findings. He states that the findings are taken out of context, but there is video and audio recording of that meeting. And again, his dispute seems to be more to going to whether or not that was a breach of the code than whether or not he engaged in the behaviour alleged. But that's obviously something that you'll consider when you reach your conclusions. Paragraph 166 relates to an email which he sent to the former clerk on the 13th of November 2024. That is at page 181 of your papers. Again, he doesn't dispute sending the email. So again, I don't think it's really a dispute about the facts. It's a question of whether or not he breached the code in sending that email that you would need to consider, which is not for this stage of the process, I would suggest. Paragraph 168. Paragraph 167 relates to behaviour, alleged behaviour at the council meeting in November 2024. Now, this is the one meeting where you do not have any video or audio recording of the meeting, and my findings in relation to that are based on the evidence that I received from the former clerk and the locum clerk before he was appointed, who both attended that hearing. Their evidence, in my view, was bolstered by the fact that their description of his behaviour at that meeting, the subject member's behaviour, was entirely consistent with what I'd seen and heard at subsequent meetings. So that's the reason that I reached the finding that I did in relation to the behaviour at that meeting, where I accept the evidential position is slightly different to the other meetings because we don't have any contemporaneous recording. Again, I'm not entirely sure he disputes that he did what he's alleged to have done at that meeting, but rather seems to suggest that he was justified in doing it and it wasn't therefore a breach of the code. Paragraph 168 relates to the meeting in January 2025. And again, there is audio, a recording of parts of, well, of all of that meeting, and then there are extracts of part of that meeting which show the behaviour. Paragraphs 169 to 172, I didn't reach any adverse findings against the subject member as a result of those, and understandably he agrees with that, so that they're not part of, I would suggest, what you need to consider today. Paragraph 173, that relates to emails that the subject member sent regarding internal investigations, and there's a degree of overlap between that finding and finding which is in paragraph 176. And the email that the subject member sent on the 4th of March 2025. And the relevant emails are at pages 279 to 285 of your papers. Paragraph 174 was an allegation I found not proved. Paragraph 175 again relates to behaviour at a meeting, this time the 11th of February 2025. Again, there is recorded evidence of what took place at that meeting, which I relied on in reaching those findings. And again, I'm not entirely sure that in his response to you, the subject member is disputing that he behaved in that way, but again argues that it needs to be considered in context and that it was justified. Paragraph 176, I've already mentioned, and that's the 4th of March email, which he sent to all members with various allegations against the former clerk. Paragraphs 177 and 178 all relate to his conduct at the 11th of March 2025 meeting, where again there is, in this case, both audio and video recorded evidence of the behaviour that I found. So in my submission, the evidence to support all of the findings is ample. Some of it's in writing, some of the rest of it is recorded. I appreciate there may be some degree of interpretation at the next stage of your process about whether it was justified or whether it was reasonable or whether it breached the code. I did ask if just a small sample of the recordings could be played, which I felt really were illustrative of the wider behaviour, and I understand you've had access to all of the recordings which I've relied on to reach those findings. Just before those are played, I'm hoping I haven't taken up my whole 15 minutes. The subject member has indicated he didn't have access to those recordings in the investigation process. My understanding from your officers is that he was sent the bulk of those which were provided with the complaint at the time that the complaints were submitted. Also, he was fully aware of what the allegations were, and he was fully aware that there were recordings available because those were referred to in the complaints. At no stage until the draft report had been issued did he ask for those. Also, they are recordings of him at events he was at, so he was obviously aware of what happened because he was there. So to any extent that he seeks to argue that he was prejudiced by not having access to those, I would suggest that that's not the case. But that may be something for you to consider at the next stage of the process. That's all I wanted to say. If we could listen to those short recordings, and then obviously I'm happy to answer any questions.
Thank you, Simon. Have you got the recording? Just setting them up there.
Apologies, Chair. We've got a video from the 11th of February full council meeting.
Move on. And I will just want you to continue.
Yeah, exactly.
You to continue.
Yeah, exactly. So actually, what I'm trying to get from you, and eventually from Michaela, is you two, you keep saying that, oh, we need to work together. Why is it not possible? Why are you raising that point? Did you try to say, okay, I got this project to do. We work together without a bin, is it? We work around. How many times we spent? We spent something on 5 days together. So why you guys keep saying that, oh, we need to start working? Can you stop? It's annoying. Seriously, it's annoying. No, it's annoying.
No, don't stop me.
I'm trying to have a conversation with a fellow councillor, and you try to interrupt.
Councillor.
Can you leave us to try to discuss between us?
No, sorry.
It's annoying.
Councillor.
No, don't say me no. Don't say no.
Councillor.
Don't say no to me, please.
Councillor.
Don't say no to me.
Stop.
Can you calm down?
No, you need to stop the clock.
No.
Don't stop me, stop the clock, because I'm trying to put a point here.
Yeah.
We need to work as a team, that's true.
Again, if it
But,
carries on like this.
huh?
So, Councillor, as the chair explained at the beginning.
So did you ask him to talk? So I was talking, you tried to stop me. He's talking, you're not stopping him. Do you find this fair?
Councillor, as the chair explained.
No, don't talk to me. Don't talk to me, please. I don't want you to take the vote over me.
Councillor, as the chair explained.
No. You need to ask the way to the chair before you take before you speak. You know that, right?
Councillor, as the chair explained,
That's the point, is it? Ashes, that's not point. Seriously, I'm pissed off because every time. No, Dan, I'm pissed off. Seriously, I'm pissed off. Every time I'm pissed off. Sorry, guys, but
there are members of the public.
I'm trying to explain the point.
Yeah,
and
but
then you stopping me. So when the clerk tries to speak something, you're not stopping me.
I've understood your point, Tamir. The time is really short.
Okay, I'm not talking.
I understood your point, Tamir.
No, you wouldn't stop.
No, I've understood your point, and I haven't stopped you. I totally understand. We've said the parish council needs to be more cohesive. You've questioned that and saying why are you guys involved, and I've totally understood that. So, but we need to just move on.
And I would just as a point like to say.
No.
Apologies, Chair, that was an audio recording from the 11th of February meeting.
Chair, can I just say your 15 minutes is over now, please?
Just to confirm, I've still got the timer running on my computer and it's not quite concluded yet.
So this is a video from the 14th of January meeting.
Chair, I insist. The timetable says we all rely to have 15 minutes, and that is more than 15 minutes now. Yeah, I timed the time as well. So we're 15 minutes, 48 seconds now.
We have it timed on the timer that was up on the board before we started the filming. So Simon, we will continue with the next film. Thank you. We all hear the councillor. We're serving this resident. None of you once say, okay, let me go and see what's really going on that fitness class. You never turn up to spend at least 5 minutes with this guy to find out what is the real benefits of that. And then this class talking about fitness class, it doesn't even know what is the real fitness class. Let me finish, please. Let me finish. I remember. Can I just finish my point? Okay. You can't constantly stop me making your point out.
Can you calm your voice down?
Yeah, but because you keep stopping me. If you don't stop me, I won't raise my voice.
No, you don't raise your voice.
Yeah, but don't stop.
No, I will stop you.
Yeah, but no.
If you're raising your voice,
no, actually, if I'm speaking,
calm down.
Yeah, calm down, but don't interrupt me.
No, I will interrupt you if you raise your voice.
Yeah, but if you interrupt me, I will raise my voice. Just let you know.
No, if you raise your voice, I will
don't interrupt me.
No,
when you speak, I don't. No, actually, I'm not playing with this. If I'm speaking, I don't want anyone to interrupt me. That's what I'm doing.
I'm going to adjourn the meeting.
Okay, go on, adjourn the meeting then. Adjourn the meeting if you want to. So when I want to say something, I don't want the clerk or any member, like all of you, when you took when you started speaking, I didn't stop you. So why is when I need to say something, you have to stop?
Thank you. How long is it? We've got how many minutes? 30 seconds.
Can we move?
So this is a small amount of money. It doesn't matter.
Is there a proposer?
Yeah, I'll second it.
Okay. Anyone in favour? So.
Some of the conflict of interest with some council together. I will make sure that it's not becoming the rule.
Sorry, are you supporting or are you against?
I was supporting.
You're supporting, so you're aware that staff may not.
Oh my God! No. You must be ashamed of what you're doing, man. You should be aware of what you're doing. Seriously.
Can you stop shouting?
You should be ashamed.
Yeah.
Tamir,
I want
You
him.
should be seriously.
No,
you should
I want him to.
be. You should be ashamed
Yeah.
when you do
Tamir,
it. Seriously.
Tamir,
What do you think? What do you think are you talking to?
Calm down.
He's your fellow.
Tamir, I'm going to
He's
call
your
the police.
fellow. So
Tamir.
you can't just talking to him like you're talking.
Thank you. That was 30 seconds over, so we have I as the chair, I have flexibility. So if yours goes over 30 seconds, that is fine. Simon, you finished? Yes, thank you. So Tamir, do you have any questions for the investigating officer at this stage?
Yeah, Chair, just for the record, the subcommittee made some arrangement about the time frame. I just need to let you know that the investigation intervention went over 15 minutes. We time it is totals 18 and 39 minutes, just for the record.
So we also have a timing which was 30 seconds over the 15 minutes.
Okay.
So
thank you.
We have accept that you have your time and we have ours. As chair, we do have flexibility. We can be bang on the second, and everyone can be bang on the second, or when we progress and other people need to have a little bit extra time, that as chair is something that we have the ability to do.
Okay, sure.
And we've
Thank
had
you.
30 seconds. So what I'm asking now for your questions for the investigating officer, and we've allocated 15 minutes for your questions. And please note they must be relevant to the findings of fact only. And I reserve the right as chair to stop any lining of questioning that goes on to the breach of code. So we're purely looking at the finding of fact at this point.
Okay. Thank you, sir.
Thank you. Thank you.
I'm just going to distribute you all the questions I'm going to ask, so you're aware of what I'm asking. Yeah.
Present documents at this stage.
It's in chair's discretion.
Chairs, we're now you're asking whether or not papers can be presented on today. Generally, we would not expect anything to be tabled in the way that this has just been tabled. But having said that, maybe it is wise for us to take a few minutes to have a read of what it is. And then you can decide whether or not you would deal with it as part of the proceedings.
I would like to ask the question whether it's appropriate, because this is taking up more than your 15 minutes. If you want us to read this, it's within the 15 minutes.
It's just for the committee's reference.
We can't accept anything that hasn't been read, though. I would suggest that we can't have a document that's put into the public domain that we haven't read or had the opportunity to read beforehand.
Okay. Understand. Okay.
Thank you. Yeah. So we're going to give the papers back if you'd like to come and collect them. So, yeah, he has finished. Are you ready now for your 15 minutes?
Yes, yeah.
Thank you.
Right. This is a serious question I would like to address, ask to the investigation. Before concluding that my intervention on the payroll item were improper, did you check whether the procurement process comply with the Council's own financial regulation, including the requirement to achieve the value of money?
Simon.
It wasn't my role to carry out a review of the report that was presented to the parish council or its compliance with procurement rules?
Chair, given the time, the 15 minutes I've got, I would like that the answer will be yes or no. I don't want any explanation. I just need yes or no, please. Thank you.
That's fine. Is that okay? No.
No, I'm not.
No, sorry.
I will answer the questions as
Yeah,
I feel
As it
appropriate.
feels approved. We have also made it very clear we're looking at the finding of fact during this questionnaire.
That's factual. Okay.
And we're focused on that, nothing to do with the governance of the parish council. We've made that clear. It's about the subject, the case that we're hearing on this meeting, not about wider parish council governance.
Okay, understand. So second question, did you examine whether the payroll contract fell within the regulation 5.8 or 5.9? And if so, whatever the requirement quote of estimate has actually been obtained and properly evidence?
That wasn't within my remit.
Thank you. Did you consider regulation 5.15, which require expenditure authorization to be supported by the minute or auditable evidence trade before deciding that by challenge to the process lacked proper basis? Did you also check that the clerk does not have delegation authority for any item above £500 excluded VAT?
I'm not really sure the relevance of that question because the report.
By respect, it's not down to you to decide which is relevant or not. This is my question. I would be really
and I'm
hopeful
answering.
to just.
I will try and answer it if
Okay.
you'll allow me.
Yeah, thank you.
The complaint was about the conduct of the subject member. The report that was presented at that occasion that the council was being asked to consider was a report which was seeking the council's approval to appoint a contractor following a tendering process. So I really don't understand what the scheme of delegation to the clerk, what relevance that has to any of it, because the clerk was putting forward a proposal for parish councillors to vote upon. Ultimately, even if there is an issue which councillors dispute about a report which is presented to them, they are perfectly entitled to question that. They are perfectly entitled to ask questions. They are perfectly entitled to.
Chair, I don't need any explanation, to be honest, and this is taking out of
No,
time.
this is Simon that has the right to reply.
And it's important. First of all, it doesn't really go to the facts. Secondly, the point I'm making is, even if the subject member had a point about the report, and there certainly may be things that were legitimate to raise and questions, the scheme of delegation to the clerk isn't, because it wasn't a delegated decision. It was the clerk was putting forward a report for the council to consider. Ultimately, it's the way that he conducted his response to that, not whether he had a valid point to raise in the first place, that is the issue.
Thank you, Simon.
Right. Did you review Appendix 1, Paragraph 3, which required sealed tenders to be opened at least at the same time on the prescribed date by the clerk in the presence of at least one councillor? And if so, would that step need to be happened here? If the councillor was bidding for the large contract, can the councillor be completely excluded from this process?
No, and I don't think any councillor raised that as an issue in the meeting either.
Samir, we need you to focus on the findings of fact relative to the complaint.
This is part of the fact. Sorry, but that's how I understand it. So this is, for me, this part of the fact.
The finding of facts are the list of facts that you have within the investigator's report, and that's what we're looking at this stage. Did you or did you not do what is in with each fact? It's not about why or the wherewithal. It's not about whether you breached, as we've spoken before. It's not about wider council governance.
Chair,
So I'm aware that you've got a limited time. Can you go through your list and
Yeah,
look at questions that refer?
Chair, I don't understand why you're deciding which kind of question I should be asking.
Because it's
This
about
are my question, and I decided to ask this question. You guys, you can decide what question should be asking. So this is what I don't find is really fair.
Just to be clear,
Can I just get it?
the questions at this point are around the finding of
These
fact.
questions are based on the meeting of the
Finding
11th
of
of
fact.
March. Yeah, that's what we're talking about, the fact. It looks like clearly the investigation didn't looking at our financial regulation because that's just based on this meeting we had on the 11th of March.
And that isn't the subject of this hearing. It is about whether your behaviour was conducted in a way that wasn't appropriate. It isn't
It's
about
all
the
linked-
wider
It's all
governance.
linked up.
It's at this stage, we're looking at the fact, did you or did you not exhibit the behaviour shown?
Can I carry on, Chair? I'm going to this. Right. Given that the council later deferred the payroll item for advice, do you accept that my challenge was capable of being legitimate governance concern about compliance with the financial regulation and tenders rules, rather than evidence of bad faith or personal animus?
As I've said, there were certainly questions it was legitimate to ask, and the council voted by a majority to defer the item. That doesn't in any way justify or excuse the behaviour that was done, that was carried out at that meeting.
I'll wait for the 11th one. Right, can I ask the committee to read page 419, 319, and 419 together, please? Yeah, it is sorry. No need to go for it there.
Just read the rest. Read the rest. The rest don't wait.
Just to make sure they're on the page. Right. Right. The page 419 shows the clerk framing the issue in his own words, namely whether he could score the court and anonymize the result before presenting them to the council. Page 399 shows that the same framing being passed on almost verbatim for external advice. The page 415 then shows the response coming back, but no resolving the issue because Mrs. Wolf says she was not very happy with it as it didn't lead the matter forward. So this wasn't a neutral and conclusive advice trade. It was a one-sided framing of the issue, which remained unresolved. In those circumstances, it was unfair for the investigation to treat my concern as they were plainly baseless or improper. So the question to the investigation will be, do you accept that the page 419 contains the correct original framing of the issue, and the page 399 repeats that framing almost verbatim when the matter is passed on for advice?
Sorry, can you repeat the second part of that? I didn't quite hear it.
So are you talking about a question, right?
Yeah, the second part of your question,
okay. Do you accept that the page 419 contains the correct original framing on the issue, and the page 399 repeat that framing almost verbatim when the matter is passed on for advice? Basically, the clerk told the advisor what to tell him, and then that is repeated.
Well, the clerk asked for advice, which he got. I mean, the premise of the question, I'm not sure how you would expect the clerk to ask the question in any other way, but yeah, clearly the clerk asked the question and he got the answer. How that relates to the way that the subject member behaved at the meeting before that had happened, I'm not really sure.
That's not a question. The question is, the clerk is instructing the advisor to tell him what he wants her to tell him.
as an advisor, I can certainly say to you, in my experience, that's not the way it works. We do not answer a question based on what our client wants us to tell them.
Right, okay.
We advise based on the law.
Right.
And in any event, in any process where a local authority is seeking advice, officers ask a question and get that advice. That's the way it works in local authorities up and down the country.
Thank you, Simon.
For the next one, you know.
The chair would just like to stop the time at this current moment, and we would like to give you the opportunity to have a full and fair hearing. And you're asking questions that aren't relevant to the finding of fact. So we're going to be concerned that you're going to run out of time for your sheets of questions at this stage to go through those questions and look at the ones that are actually addressing the finding of fact, not looking at whether you've breached a code, but looking at did you or did you not do what is in those finding of facts. So please look at your questions, tell me when you're ready to start the time, and we'll continue, because I want you to be able to say what you need to do, what you need to say relative to this question.
Thanks, Jack, for your concern, but I just feel it's not fair for you to ask me to try to lecture me on the way I should be asking the question. So these questions I'm asking are based on the meeting of the 11th March regarding this Peter, and then I don't understand why you want me to ask a question that's going to fit you. I'm asking the question based on what I think the process wasn't fitted properly, and then you're not happy with that, and then you want me to ask a question that's going to be aligned with your expectation. I don't understand that. Sorry.
Okay, so the stage we're at is the finding of fact. And I don't want you to not have the opportunity to ask those questions, but if you prefer to continue with the questions that you have.
Yes, Chair, because it's
At
clearly...
time, when we get to 15 minutes and 30 seconds, we will be stopping. There won't be any further time. So I just don't want you to be able to say, I haven't had a chance to ask this and this is really important. So that's all I'm asking you to reflect on. I'm not asking you to ask a particular type of question other than what is required in the process that we're on stage one, finding of fact.
Right. There's a missing fact on all the evidence that has been provided to me that I finally found based on the financial regulation of our parish councillor. I'm raising these points because clearly the investigation didn't looking at those financial regulation based on what I just raised as a point. For me, it's factual because it didn't looking at it. That's factual.
Simon, would you like to respond to that? No, thank you. So continue with your, put the clock back on and we'll continue with the questions.
Right. Do you accept that the page 415 shows the response coming back without clearly resolving the issue, since Ms. Wolf said she was not very happy with it as it didn't lay the matter forward? Well, I'm talking about the financial regulation.
It says what it says. It doesn't. It does say, I'm not very happy with it.
Third one. So if the advice tray both began with the clerk framing and ending and conclusively, on what basis did you treat my procurement concern as lacking foundation?
Well, on your own, the basis that you're putting the questions, you weren't aware of this information at the time that you said what you said at the meeting. The debate at the meeting was around anonymisation of the bidders and whether the councillors needed to know the names of the bidders in order to decide who to appoint. So that was the question that was being asked at the time and after the event. And I would go back to the point, the decision I made and the conclusions I made, and I would suggest at the next stage of the process, the conclusions that I would invite you to make are that regardless of whether there were any legitimate concerns that councillors had about the process, they were not raised in a way which was consistent with the code of conduct, which was respectful, which was reasonable, or which was justifiable. And I think it's a really important point to make. I think there have been lots of points that have been made towards the clerk and towards the other complainant, which are wrong. And even when such as that a councillor's company cannot provide services to a council, and even when the subject member and other members have been clearly told that was wrong, albeit they may have been given incorrect information previously, they have not accepted that and have persisted with their view. But anyway, even if they were right, and they were completely right about everything, they're entitled to raise those issues, but they still got to raise those in a way which is consistent with the code of conduct and respectful. And that's the point, I think, that the subject member just is not grasping, doesn't want to grasp, doesn't accept, whatever. But that's the basis of the decision. So, you know, we can spend all the time we want looking at the decision that he wasn't very happy with, but that's not the point. The point is, even if he's right about that, which I don't think he is, and he wasn't raising some of the issues he's now questioning me about today at the time, the way he went about it was still a breach of the code.
Sian, could you just update on the time as it's not showing on the board at the moment?
Yes, Chair, there's roughly about 4.5 minutes left of questioning.
Thank you, Sian.
Did you really react on a full recording of each minute, or as you guys, the subcommittee just show on the screen, or did you only extract a selected part of the video and supply by the complainant? Were you supplied with a recording by Councillor Chandra? Why have they not been provided on the hearing panel?
I was provided with a number of recordings by both complainants via the council, and Councillor Chandra provided me with some recordings. My understanding is you have all of those. They in total take up some hours of time. I listened to the meetings that I had full recordings of. I listened to at least twice the full recordings. Some of the recordings that you've had, and the ones that you've had today were extracts which were supplied by the complainant. So I totally accept that they are extracts, but I have listened to the recordings of all the meetings I have. Clearly, you don't have time to do that today because it would have taken up all of today just to listen to the recordings if that was what you wanted to do. But I understand you have had those, and obviously you're able to listen to those. And certainly I can say,
can I just say that is wrong, because I wasn't supplied with all this evidence until this committee has been decided to go on, and then I request to have all this recording. So it's wrong to say that your understanding was that I had all this, I have access to all this document. I wasn't. So
well, that's what I was
and then
told.
Based on
that's what I was told.
Can I just based on your investigation, you should make yourself or myself aware about, or let me have access to all this recording, but you didn't. The second question, where in your report do you explain the limitation of relying on selecting the recording rather than a complete and neutral recording on the meeting? Because what you showed there was extract of part of the full recording, which is obviously for most of the people here, they didn't attend those meetings. If you extract part of the meeting, that's going to show me, okay, I'm a bad guy, I'm a bad dog in here. So this is no fair as an investigation. You should be having access to hold the recording and show the whole recording. People can make demand instead of extracting part of the video.
I have been told that when the complaints were sent to you, you were sent copies of the recordings. Also, you were fully aware there were recordings because they are referred to in the complaints. At no stage when the 2 times I interviewed you or at any other stage did you say, please, can you send me copies of the recordings? So you had ample opportunity to request those if you wanted them.
Okay, thank you.
And I am told that you already had them.
Okay. So
in terms of the second part of your question, 2 things. One is, as I've explained, I have extensively listened to the full recordings of the meetings that I have, and that relates to the
I need to carry on asking my question because I don't really want to always explanation because I know that's
it's an important enough question to ask. It's an important enough
because
question
but
to
the thing is, you know, answer my question.
We've already gone into the last minute.
Exactly. So because you don't answer my question, so
I am I'm trying to answer your question if you'll let me. So I had full audio recordings of the meetings of 14th of January and the 11th of March, and partial recordings of the meeting in February. I listened to everything that I had. I listened to the full recordings more than once. I also do not accept the premise that taking those extracts out is an unreasonable thing to do. I also do not think you need to be put through what I was put through in having to listen to all those hours of recordings. I think it is perfectly legitimate to look at and hear what you've heard this morning and reach conclusions on the behaviour of the subject member and whether it was reasonable or not and whether it breached the code. The suggestion that something can be taken out of context when it happened, when it isn't denied that it's happened and can't be relied upon as evidence is just wrong. And you see it in criminal cases all the time. You will see CCTV recordings which show part of they don't sit there and say, I have to watch the last 5 days. They watch the relevant parts. They listen to the relevant parts. It was perfectly reasonable for me to do that. It's perfectly reasonable for you to do that.
Thank you, Simon. We have come to the end, but I'm going to allow Tamir 2 more minutes. But I would just like to say, as the chair of the committee, I did listen to those long recordings whilst I was out walking. So I have listened to the recordings of the full meetings. Thank you.
Chair, thank you. Can I just ask, for my last 2 minutes, is it possible to ask the investigators and just to respond by yes or no? Because I only have 2 minutes left. No. Right. Okay.
Please choose your most prioritised questions for the 2 minutes. On this time in the 2 minutes.
Right. Okay. Yeah. So at paragraph 211, you accept there is some merit in my complaint that Mr. Fuller frequently interrupted me. How did you factor those interruptions into your interpretation of the recording?
Well, I think the paragraph speaks for itself. And I don't think he was very happy with my comments about him. It's not necessarily a legal rule, but it's a maxim I've always lived by: the 2 wrongs don't make a right. And whilst Mr. Fuller maybe did interrupt the subject member more frequently than he could or should have done, that didn't warrant or justify the response that came to that. And it wasn't just him, as you've heard from the extracts, it was the chair. The respect for the chair and allowing the chair to conduct meeting is a very important principle of local government. And it was quite frequently the chair who was on the receiving end of the subject member's comments, not just the clerk.
Did you identify anywhere in the recording where the chair or the clerk raised their voice, interrupting or contributing to the disorder? And if so, why is that not analyzed with the same care as my conduct?
I wasn't investigating any complaints about the conduct of those 2 individuals. The chair, well, if you let me answer the question, the chair generally, in the extracts I heard, occasionally did raise his voice in response to trying to regain control of the meeting which had been lost because of the conduct of the subject member. If you listen to the whole meeting, and if it's just from the extracts you've seen, I felt very sorry for the chair in trying to chair those meetings, and I'm surprised that he continued to stay as chair for as long as he did, because it was very difficult for him. So I'm not saying they behaved perfectly, but they were put in a very difficult situation, and certainly whenever I heard the chair raising his voice, particularly, or the clerk, it was a response rather than them initiating it.
Would you accept that a recording can capture my reaction, but not necessarily the full context that caused it, and that is require caution before turning disputed exchanges into finding of misconduct?
I think the recordings speak for themselves. They're evidence. Clearly, they need to be treated with the evidential value that they've got. But I think in conduct investigations, they're the strongest evidence you're going to get, and it is, in my view, very easy to form an opinion based on the audio recordings and the video recordings of what happened and who escalated the issues and who was behaving reasonably and who wasn't. Perfectly easy.
Thank you. That is the end of the 15 minutes of extra time. And we're now going to move on to, do any members of the subcommittee or independent person have any questions they would like to ask at this stage? No. Thank you. Now we will hear from the subject member on the finding of fact. Please could you make your representation, including hearing from any witnesses with evidence relevant to the finding of facts. And I reserve the right as chair to stop any line of questioning that isn't relevant to the finding of fact.
Obviously, Chair, you all received some of the witness statement. All I need to say is there's some missing fact that I'm trying to raise, but obviously I didn't have all the time based on the short time I have to prepare this hearing. A lot of evidence, like the recording audio, as you saw, you also on the video that has been played, or the audio that has been played, that has been extracted. I don't know you guys if you all listen to those audio entirely to really decide whether my behavior was just something like all of a sudden I decided to raise my voice, because when you try to put your point and then you have a clerk who keeps stopping you without even listening to the chair, because the clerk can just start addressing the councillor without having a way from the chair. And then I have two challenges, which was to say to the chair that it wasn't fair to let the clerk try to address councillor without passing through him. But at some point, I just found it was enough for me to just keep letting this clerk talking over and over the councillor. And then also, some of the evidence I didn't receive at that time. I did request twice to have access to all this recording, so I couldn't go through it myself and then make some decision. I have it lately. I went through some of it. And then from my understanding, when I said some of the video that has been shown has been extracted, but they didn't show all those video where I think that my behavior was triggered by over behavior from the clerk, particularly. That's what I would say.
Have you finished, Tamir? Yeah.
Give me 1 minute, please. Oh, okay, sub-second. I just need to double check.
Have you finished, Tamir?
Yeah, I think that, yeah, I'm done.
Right. Any questions? Where are we now? From Simon, any questions, please?
Yeah, but I'll try and be as brief as I can. You told me when I interviewed you that you were employed by Tesco between December 2015 and September 2025. Is that correct?
Yes, it is.
And when you completed your register of interest form on the 1st of August 2024, therefore, you were employed by Tesco. Is that correct?
Yes, it is.
And there's a box on the form. The form is at page 381 to 383 if it helps. There's a box which asks occupation, and that's that you've written none next to that on your form in August 2024. Is that correct?
As I previously said, that was a mistake. And once again, is the clerk responsibility to go through all this and to make sure that the DP has been properly filled. I already explained all that to you. Thank you.
So can you explain, well, the clerk will have seen that you wrote none next to employment.
Say that again, sorry.
Next to employment, you didn't leave the box blank. You wrote none, didn't you?
Yeah, probably, yeah. But as I said, it's not my responsibility. It's the clerk responsibility to make sure that all that form align with all the declaration. And I did say at that time, I have an appointment with the clerk's son, if I recall. And then we have an appointment to make sure that all my paperwork will properly filled. She haven't done this job. I'm not blaming her, but she haven't done his job properly. If she did her job properly, she wouldn't call me out on that. So I didn't do that on purpose. And yeah, thank you.
If you'd written none in the box next to employment, how would the clerk have known that you were employed by somebody?
Right, okay. Once again, I spent nine years in Tesco's. If I've been elected on this parish council and running a lot of projects, it's because of my connection with all the customers I met in Tesco. Right, I don't understand why you keep challenging this. I done it on purpose, and this is really not fair. We talked about that several times. I was with Tesco. I spent 9 years to Tesco. I met a lot of people. That's the reason why I committed myself to serve this community. So I was in Tesco. If I made that mistake, yeah, I'm accountable to that mistake, but it's down to the clerk to make sure that all the paperwork was fully checked. The previous class did it. I don't understand why the second one didn't know that. Thank you.
Thank you. The meeting of the 11th of March, would you accept that you made disparaging remarks about the company that supplied the payroll contract at the time, which was owned by two councillors?
I don't understand what you're trying to say. Can you clarify? What do you mean by disparate comments?
Were you critical of them? Did you say that they couldn't be?
You're still not saying anything. This is vague. Can you literally say what I use? So it's really vague. So if I'm voting against a councillor who tried to bid for the services for the clerk where is serving to, for me, is a conflict of interest. I won't be able to do that. So when you say that, do you recognize that I made a comment? Which kind of comment are we talking about? I'll vote again because I don't think it's fair for me, if I'm serving my community, to try to get the money off of it. That's not how I see the commitment for my local residents. So if you want to ask me the question, please just be clear on what you try to ask, because if you're asking me the vague question, I'm going to give you a vague answer.
Thank you. Also at the meeting of the 11th of March, at the end of the meeting, when there was a discussion about the payroll contract, you made a reference to corruption in Africa. Is that correct?
No, I didn't. Sorry.
So you didn't use the words corruption in Africa?
I was talking about corruption in Africa because obviously, as you can see, I'm a black man. I was born in Africa, so I know what's going on there. But me talking about corruption in Africa, how do you decide is I'm linking what is happening to Africa, and obviously we're talking about AP. So why are you deciding? This is purely interpretation, because you try to link my comment to assume that I was saying that EP company was corrupted. That's what you're assuming, is it? So if I'm making a comment based on what my experience back in Africa was, I was born, so that doesn't necessarily say that I'm saying that this company is corrupt. I was against the fact that a councillor tried to bid for the services, me voting against it, and then remind me of certain things. That doesn't mean I'm saying that is a corruption. I'm saying it's not fair for me. There's a conflict of interest of a councillor try to bid for the company with his company in the parish councillor that is serving. That's it. That's my understanding.
So immediately before you made the comment, so you accept you did make the comment about corruption in Africa at the end of that meeting?
Yes, that's correct. Yes, that's correct.
And that comment was made immediately after Councillor Chandra made a comment. There was a discussion about that item on the agenda, and Councillor Chandra said which of the anonymised companies in the report was the company owned by the hippies. And immediately after that, you made a comment about corruption in Africa. Your evidence is, though, that had nothing to do with the conversation which was taking place immediately before you made that comment. Is that right?
No, it's not right. This is you making some assumption. No, this is being biased. So if I made a comment, that's a freedom. I'm not free to make any comment. So if I made a comment, you definitely think that this comment is linked up to something, is it?
Well, usually the way.
So you are denying me as a councillor any freedom of comment.
No,
that's the way I say. So if I made any comment, no matter the way the discussion we're going through, if I made any comment about something which might be irrelevant as well. So I don't understand why you're assuming that my comment was linked up to the fact that we were voting about this barring. Why are you assuming that? That's you being biased as an investigator.
Well, the way a conversation normally works is if you're talking about an issue, if someone's going to change the subject to talk about
but the way things work in your side, it's known as we have a different background. You're white and black. We have different culture. The way things work in your side, it's not necessarily the way things in my side. So the way you are judging, you got to frame. You are having your glasses. You need to read my word based on your experience and your glasses. Though you can't just say the way things work. You can't lecture me the way I want to think.
So the position is, just so I understand it, you accept that you made that comment. You accept that you made that comment immediately after a conversation was taking place by others in the room about that contract, but your position is that that comment was not a comment about that contract or related to that contract in any way. You just decided out of the blue to make a comment about corruption in Africa completely unconnected to the conversation that was taking place before. Is that your position?
So I'm really being comfortable with the way you are phrasing things, because if you see the whole context of things, because you don't see the whole picture of things. At that time, the chair was trying to force the vote. This is why the way the video would just play where Councillor Anthony voted against, and the chair by that time, Ashish, wasn't happy, and then the chair starting to challenge the councillor. He was trying to force the vote. So, and then the way you keep insisting on the fact that my comment was linked up. I definitely, my feeling is you definitely want me to recognize that my comments were linked up on that. And then that's the fourth time you're just asking me the same question. And the fifth time again, I'm telling you, the way you see things or the way you see things is different than the way I see things. And then I'm free to share my opinion. And then my opinion doesn't mean that I'm saying that EP company is a corrupt company. Why would I say that? What kind of evidence I say that? All I'm saying is I don't feel comfortable as a councillor to see another councillor try to service his own community by saying that, okay, I got a company, I want to serve the company. For me personally, based on my value, for me, it's a conflict of interest, and then I will never vote for it. I say thank you.
Okay, I think we've taken that as far as we can. The meeting on the 11th of March 2025, did you ask the clerk if he was pissed? And I think by pissed you didn't mean that he'd been drinking, but that he was unhappy with your behaviour. Did you use that word?
Who was pissed? I don't understand.
The clerk.
Why would he be pissed? I don't understand.
I think you were using it in the context of angry rather than drunk, but did you use that word directed at the clerk at the 11th of March meeting?
Drunk?
No, pissed.
No, I don't recall that.
Okay.
Sorry, I don't recall that. Sorry.
No. At the same meeting, did you say to the clerk that he really had a problem?
Right. Okay. Sorry, I just need to check something to reply on that question because I have it somewhere.
To me, I will be asking Simon if he needs some extra minutes as we've had some delays during your questioning. So
I'm happy to stick to the 15 minutes.
You are. Thank you, Simon.
I don't understand what delay are you talking about? Sorry.
I've just asked Simon if he needed some extra time after his 15 minutes as we were losing some time with your conferring.
I think if
okay, I'll go that now. So the wording went from you are going to have a problem to you really have a problem, right? So I really don't understand because I was trying to explain to challenge the clerk behavior. Obviously, the clerk behavior was really unacceptable.
So you accept that you said that he really had a problem?
Yeah,
yeah.
Because his behavior is have a problem, clearly. Yeah. But the wording has been changed. Obviously, the wording has been changed by from you are going to have a problem to you really have a problem. Because I was challenging clerk behavior because he didn't really care about what the chair was asking him to do. He was straight away addressing the clerk, and then I was just something's wrong with you, man. So you're not supposed to be behaving the way you're behaving.
We've heard the audio from the meeting on the 11th of February where you said, I'm pissed off, seriously, I'm pissed off. So you accept that you said that in that meeting?
You already heard that. I was based on the, but that's the thing. So you're taking the word after the general concept and then you're making a conclusion on that. I just think that's not fair. So before you try to extract, the same way you extract videos on a meeting, you extract one word and then you don't even see the whole context on the discussion, because literally the clerk behavior was really unacceptable. And then your way to conduct the investigation is you will extract a word just to say, okay, this councillor is misbehaving, but you don't at any point you challenge the clerk behavior, the way he was talking to people, the way he was addressing the people. I don't even recall one of the meetings when Councillor Shonda as, okay, I'm respecting the asking the clerk chair to know to address to councillor, and then the clerk straight away responding to him saying that I will address you whenever I want. So at any point during your investigation, you raise the clerk behavior. The only thing based on what I read or what I listened to the audio recording is you try to extract words from what I was saying, but at any point you challenge the clerk behavior, and then that's the reason why I really think that that's not fair and unfair and biased.
No more questions, thank you.
Yes, Chair, if I may. Temur, can I just check when the videos and audios was shared with Temur, and if they were, when was it?
Thank you, Shah.
So to just clarify from our position, the recordings that we were in possession of that we received as part of the 2 complaints were sent to the subject member when we initially informed them of the complaint. That was on March the 18th, 2025, and that email is available on page 476 of the pack. I did review the link when the subject member asked to have the videos again. That link remained live, so that has been accessible at any point since that email was received. And all the recordings that we were in possession of were resent to the subject member when he requested those. So he requested them on the 22nd of April and they were sent on the 23rd of April, so yesterday.
Thank you, Shah. Any further questions?
Thank you.
Can I just respond to that one? Was that? Is it okay to make a comment? No? Yes?
You've already made your
Okay,
point
that's
clear
fine.
that,
So-
that you haven't received them.
No, I didn't,
And
because those
we're just answering
And then
the
Sian-
question. So I'd like to
Okay.
just move on from there.
Thank you, okay.
Thank you. And just a question for the investigating officer, just to ask, do you think you've been presented with anything today that is not covered in your report during this first part of the hearing?
No.
No, thank you. So thank you all. I will now ask the investigating officer to sum up the main points of his argument relating to the findings of fact. Simon, please sum up.
I really don't think I need to say anything. I think you've heard enough. There's nothing to add to what I said at the start. I don't think in the evidence that you've heard or the representations you've heard, it changes anything I said in relation to the findings of fact and the reasons for them. So I don't think I need to take up a further 15 minutes of your time.
Thank you. And now if I could ask the subject member to sum up the main points of his argument relating to the findings of facts only.
Mainly, I would say, based on my question, I understand that the investigator didn't go through some of the document, like the financial regulation, because obviously it's linked to these payroll services. It clearly, the investigator didn't look at our financial regulation.
Tamir, that wasn't the subject of the complaint. That's why those weren't gone through.
Can I just ask, where are we in the time framing? I'm a bit lost, sorry.
On the summing up, we are.
We don't have a summing up here.
It is. I'm just looking in terms of.
Yeah, but if I need to follow you guys, I need to. We don't have a summing up in the time frame you just shared with us.
So the chair's given you an opportunity to sum up, as she's just given the investigating officer.
Yeah, Sharon is not in here.
Okay, so it's the chair has the discretion to change the procedure on the day. It's She's exercising that discretion to give you more time in this instance to sum up your position on findings of fact.
Okay, thank you.
Any further comment?
No, thank you.
Thank you. So the subcommittee will now retire. Before we retire, I've been asked if we can take a comfort break. So we will take a comfort break. How long do we need for that?
About findings of fact.
Yes. So the question I asked was, do any members of the subcommittee or the independent person have any questions they'd like to ask? So yeah, Aisha answered with a question. So have you not had the opportunity to ask what you'd like to ask? Sorry.
Chair, you ask about questions and I said no.
Yeah.
But now you're moving into the finding of facts with the committee to
Yes.
go out.
Yeah.
But before that, is it not an opportunity for the independent person to give their view on the findings of fact? Because you are into a three-stage process.
Yeah.
Having got the facts or agreed the facts with the committee, you then come back in and there's further about, does this breach the code of conduct? And at that stage also the independent person can give their view about breaching the code or not.
Yeah.
But at this stage I ask, can I give my view on the finding of facts?
I did ask that question, and in the code of the hearing code, it gives the opportunity for the independent person to ask after the summing up of the breach of the code of conduct and the sanctions. But I'm quite happy for you to take this opportunity to also sum up here. Thank you. That would be helpful.
Thank you, Chair. I'm obliged to you. The facts as presented by the investigator and his report were basically three elements to it. The first one was about declaring an interest about working for a company, Tesco, and I find that I agree with the investigator that that was not declared for by the subject member at the appropriate time recently. Although I recognise that it was declared on the first occasion, and the evidence shows that very clearly. The second fact is I think it's the investigator's word, the behaviour of the subject member towards the clerk and the various elements that took place to, if you like, disrespect or the behaviour was not appropriate towards the clerk. And I find that that has not been disputed today, and that the elements which are highlighted by the investigator's findings, that is page 81 onwards, I find that those are factual and have been proved today. And finally, the subject member's general behaviour, which is the third element, general behaviour at meetings, I find that that has not been denied today. It's been illustrated as part of a context, and that may follow in the second part of the hearing today, but as a finding of fact, the various elements, the use of unprofessional language, and also the interruptions and speaking over, that sort of behaviour, I find all of those as illustrated by the investigator to be factual. Thank you.
Thank you. So we're going to take a 10-minute, is 10 minutes long enough for a comfort break for everyone? And then we're going to move into the room where the subcommittee will retire to consider the representations and evidence in private before making a determination on the findings of fact, on the balance of probability based on the evidence that we've received at the hearing today. And as part of this, the subcommittee may at any time return to the main hearing room in order to seek additional evidence from the investigator, the subject member, witness, which we haven't had, or to seek the legal advice from or on behalf of the legal advisor. So we will move to another room to do that. Thank you for this first part of the meeting. One back. Thank you for all your patience. We have now completed our deliberations on the findings of fact, and the subcommittee decision on the findings of facts are in line with the investigator's report. We consider the context point raised by the subject member, but we are satisfied that the recordings provided are substantial evidence in supporting the findings of fact. For completeness, the findings of fact are as follows, with the relevant paragraph of the investigator's report. That the subject member, 1, claimed to be project manager for the council when there was no such role, paragraph 163. Number 2, failed to declare his employment with Tesco on his register of interests, paragraph 164. Number 3, made disparaging remarks about a supplier to the council owned by 2 other councillors, paragraph 165. Point 4, made a reference to there being corruption in Africa where contracts are given to friends, implying there was corruption in the council, paragraph 165. Number 6, sent an aggressive and dismissive email to Mr. Fuller on the 11th of November 2024, paragraph 166. Number 7, at the November 2024 council meeting, was openly hostile and aggressive towards Mr. Fuller, repeatedly interrupting and shouting over him, paragraph 167. At the meeting of the council on the 14th of January 2025, council meeting shouted over Mr. Fuller when he attempted to speak and aggressively interrupted the chair and other councillors, banged his hands on the table aggressively when asked to moderate his behaviour and refused to stop shouting after being warned by the chair, paragraph 168. Number 9, sent emails to all councillors, copying Mr. Fuller in, asking for a meeting to discuss internal investigations, paragraph 173. Number 10, at the 11th of February 2025 council meeting, repeatedly shouted at Mr. Fuller and the chair throughout the meeting, used inappropriate language, including shouting that he was pissed off, and told Mr. Fuller to shut up in front of councillors and members of the public. Paragraph 175. Number 11, on the 4th of March 2025, sent an email to all councillors making further allegations and insinuations and suggesting that Mr. Fuller was in breach of code of conduct and his employment contract, paragraph 176. Number 12, at the 11th of March council meeting, repeatedly shouted at both the clerk and the chair, acted aggressively and refused to comply with the chair's instructions to restore order. His behaviour was found to be rude, insulting and disruptive, making it impossible to conduct council business, paragraph 177. Number 13, during the 11th of March meeting, turned to Mr. Fuller and stated, "You really have a problem," paragraph 178. We also agreed with the facts not proven by the investigator. Now, I'd just like to ask Sharon to just give us some legal advice on moving into the next section.
Thanks, Chair. During their deliberations, the committee asked me to give some legal advice on the remit of the subcommittee and what we are all doing here today. So the matter that is before the subcommittee is determination of 2 code of conduct complaints made against the subject member. The subcommittee is not investigating complaints about other councillors in this session, nor does Milton Keynes City Council have jurisdiction over the conduct of parish council employees or the governance of a parish council. And that was the basis on the chair's challenges of questions earlier being irrelevant at the findings of fact stage. We're following a procedure here, Chair, that has 3 distinct parts, and we've just finished. You've just deliberated and decided on your findings of fact, and we're now moving to determining whether or not these facts amount to a breach of the Code of Conduct in the context of the 2 Code of Conduct complaints made against the subject member.
Thank you. So we now move on to the second stage of the meeting, where we consider whether, based on the facts that have been found, the subject member has failed to follow the code. Again, we will hear first from the investigating officer and any witnesses they wish to call, followed by the subject member and any witnesses they wish to call, before both parties have an opportunity to sum up the main points of their argument. At any time throughout this process, the subcommittee may question anyone present, and both the subject member and the investigating officer will have the opportunity to challenge evidence put forward by the other parties' witnesses. Following this, the subcommittee will retire to make a determination on whether the code has been breached. Please would the investigating officer make their representation as to whether the code of conduct has been breached.
Thank you, and I think I can be fairly brief. So that I've set out my rationale for my conclusions that the council has breached the code at paragraphs 179 to 198 of my report, which is at pages 85 to 90. And again, I won't go through, well, on this occasion, I won't go through these line by line. I will, because it's set out there for you to consider, and I know you will have read it. If we take the 3 broad headings of behaviour, though, that I mentioned at the outset, and we look at the failure to declare on his register of interest form his employment at Tesco, his response to that is, it wasn't a deliberate concealment and the clerk should have checked it. Neither of those are defences to or mean that he hasn't breached the code. He's breached the code. The question is, in terms of the next stage, whether you impose any sanctions, whether you believe his mitigation for not doing it is reasonable and how serious a breach you consider that to be. He says, well, clearly it wasn't deliberate because he declared it on the form that he completed 4 months earlier. The flip side to that is he obviously knew that there was a requirement to complete the form and put that in and didn't do it 4 months later. Whilst it may have been a mere oversight, and you may think, well, you know, these things happen, it is an important process because it enables local residents to understand how a councillor might be influenced by issues in which they have a financial interest. And clearly, if there's a planning application on behalf of your employer, that's something residents might think they should be aware of. And that's the very purpose of having the register of interests. So in my view, it is significant. We don't know why he didn't do it, why he made that mistake, and whether it was deliberate or whether it was just a pure omission because he was busy that day. But it is a strange omission to write none next to something which is a fairly clear question and which you'd filled a form in 4 months earlier and filled it in properly. And I have to say, his answering of questions saying he wasn't blaming the clerk, but the clerk should have checked it, well, and wasn't doing their job. Well, actually the clerk isn't responsible for checking that. And how would they know that he was employed by somebody when he'd written none on the form? And he is trying to blame the clerk when he should just take responsibility and say, I made a mistake and I'm sorry. And that would be probably sufficient. In terms of the emails which he sent to the clerk and other councillors, the issue again is not, I'm not saying, and never would say, that councillors don't have the right to challenge employees in the way that they conduct their business if it affects that councillor, if they think that there are issues with that. But again, it's about the tone of doing that and also following the right process, not sending an email to all councillors making a range of accusations which may or may not be made out but need to go through a proper HR process. So it's again not looking at the substantive comments and whether or not there's any truth in them or not. It's the way they were made, how they were made and who they were made to, that in my view means it's a breach of the code. In relation to the conduct at meetings, You've heard parts of that. You've heard what the councillor had to say. When I interviewed the former clerk, I must admit, he said to me, well, you've heard the recordings, you know, is it not an open and shut case? Well, it is an open and shut case in my view. And certainly I would accept and have said, although the former clerk, I don't think agreed or wasn't happy with it, that I think the former clerk could have in their written correspondence and the way they engaged in meetings, maybe done things a little bit better to try and de-escalate things rather than escalate them. Having said that, that in no way excuses or justifies the way in which the councillor responded to that and engaged. There's never, in my view, a justification for a councillor shouting that they're pissed off in a public meeting. It just goes beyond what is, you know, reasonable behaviour. If the councillor acknowledged that, showed some insight and said, yeah, I was provoked, I was unhappy, I responded in a way which perhaps I shouldn't have done, and I'm sorry, that would have been the end of the, in my view, that should have been the end of the matter. Either at the time, either when the complaint was made, or even when I produced my report, I said, if he apologises, then I think that's sufficient. But he has chosen to double down, to blame other people, to try and justify his actions, which, in my view, are not justifiable and are a breach of the code, whatever the provocation. So I've set out my analysis. I've set out the paragraphs I think he's breached in relation to which elements of conduct. I don't propose to take you through that. I have also touched upon the requirement that you will have to, in terms of considering whether or not a finding that he's breached the code breaches his rights under Article 10 of the European Convention on Human Rights. I've set that out on page 91. That's a qualified right, so it protects freedom of expression, but there's a limit on that if it has an adverse impact on others. And in my submission, when you go through the three-stage test, which I've set out, which the courts say you have to, finding that he's breached the code is a justified interference with his Article 10 rights because it's necessary to protect the rights and freedoms of others, particularly the complainants in this case, and also to uphold the integrity of local government and the way local authority business is conducted. So I'm happy to answer any questions, but I don't have anything further to add.
Thank you. Tamia, do you have any questions for the investigating officer at this stage? We've allocated 10 minutes for your questions. Please note they must be relevant to whether the code of conduct has been breached only. And I reserve the right as chair to stop any line of questioning I deem irrelevant. So we're not discussing the finding of facts. We're moved on. We're looking at whether the code has been breached. So questions relating to that, please.
Right. Okay. I'm going to ask a question related to the code of conduct, whether it's been breached or not. You said that the LGA guidance, that's whether the conduct is disrespectful depend on the full context. Why does your report often isolating the phrases and moment rather than analyzing the whole exchange?
Well, I have considered it in the context I've said. I've listened to all of the recordings available, and what the LGA what I've said is, no matter what the provocation you perceive there to have been, that behaviour is unacceptable in any context.
Yeah, but at any point, the clerk behavior or the check behavior has been reported or analyzed on your behalf. Same that apparently have been you guys often you just said the way the tone used toward the clerk was unacceptable. But I shared with yourself a serious email received by the clerk, not only toward me, but other councillors as well. The way the clerk used to talk to people, to councillor, was as well unacceptable. But at any point that has been raised, the clerk managed to lock our email, councillor email. At any point that you raised the fact that the clerk denied me a training None of this has been raised. That's why I keep saying that your investigation was quite-biased.
Well, it's not true to say that I haven't raised some of those issues. In fact, I mentioned them.
That hasn't been mentioned at any point in your report. The tone used by the clerk toward me, that hasn't been mentioned. The clerk would deny me to have a financial training that has been raised, that has been reported in your report at all. Sorry.
The clerk, I did ask the clerk about that, and he denied that he prevented.
That's not my point about you asking the clerk. I shared with you several emails that the clerk denied me the financial training. I sent you several emails about the tone used by the clerk toward me, but at any point in your report that has been highlighted.
I have both in my report and when I presented my report indicated that I think sometimes the clerk's tone, both in the emails and the meetings, was not particularly helpful and could have been ameliorated and moderated. But that does not justify in any way the response that it got. There's two elements to that. One is actually the clerk never swore in meetings. The clerk only raised his voice in response to raised voices raised at him before in what I heard. The clerk's comments in emails were generally in response to allegations or assertions made about his behaviour. He denied that he prevented the councillor from attending finance training, and I don't believe the emails that were provided to me proved that was the case.
Did you check with the provider whether it was true or not? Because I give you all the detail. The provider, I called the provider, say I expressed my interest toward the clerk before some of my fellow councillor, but all my fellow councillor were entitled to follow that training. Did you check with the provider whether or not?
I don't recall you providing me with contact details for the provider. Maybe you did, but I wouldn't have contacted them anyway. I think the point, again, that I would reiterate is if there were failings on the part of the clerk, then they are not something that you or I have any jurisdiction over. There is a process to follow if a councillor has a complaint about the clerk. That is not to send them or other councillors threatening emails. It is not to shout at them in meetings. It is to raise them through due process. So whether or not the clerk had behaved in a way which he shouldn't have done, it did not warrant the response that he received. And there was clearly a conflict of evidence around some of the allegations that were being made against the clerk.
Is it okay for the clerk to be disrespectful toward his councillors, but it's really bad for the councillor to challenge the clerk behavior? That's what you mean, is it?
No, and that's not what I've said, but there are different processes to be followed. An employee is subject to employment law and employment processes. If a councillor of any local authority believes that an employee is not behaving in a way which is consistent with their obligations as an employee, then there is a disciplinary process which needs to be invoked and followed. And that needs to be dealt with in a professional way. That does not, even if an employee is behaving in a disrespectful way, and I have to say, although some of the correspondence the clerk wrote, I would not have written in the tone or manner that he did, I don't think it strayed into an area that I would have said was disrespectful towards any councillor. But ultimately, that wasn't a decision for me to make. But firstly, you did not follow the right process to raise your concerns. And secondly,
this is not true. I did provide you with my email to the chair at that time, which is Ashish, based on the clerk behavior. I did ask Ashish that the disciplinary procedure need to be put in place based on the clerk. You didn't mention that either.
Because that wasn't part of my findings against you.
Why is that? You're just talking about I didn't follow the procedure. I'm telling you that I did write to the clerk at that time, Ashish, based on the behavior of the clerk. I said to Ashish, right, based on this fact, based on this email, I shared those emails with the clerk, with the chair, and the chair didn't follow the procedure because that was down to the chair to apply those procedures. And then I shared it to you. And now you're telling me I didn't follow the procedure when I shared all this detail and the chair decided to follow those procedures. And now you're accusing me for not following the procedure. So you need to, I'm getting confused here.
Could I just interrupt? The clerk and the chair are not under investigation here. They're not the subject of this investigation. The subject, as I said to you at the beginning, we're going through is has there been a breach in relation to our findings of facts today? And that doesn't include any complaints about the clerk or the chair. They would have to come under a separate complaint into the standards process. We are looking at the 3 items that Simon said, whether the Tesco, the emails, and whether the behaviour meetings was appropriate about yourself. We're not under investigation for the clerk or for the chair. So can we be clear that we don't wish to have any more questions along those lines, because that isn't the subject of this committee today. Thank
Chair,
you.
if I may.
So we need to move on now.
If I may,
Move on to questions that are appropriate. Thank you.
Can I answer that question? Because I think, in fairness to the subject member, in the context of what I said, it was a reasonable question to ask. The point is, the email which he sent to the then chair asking him to instigate a disciplinary process is not something that I have found to amount to the breach of the code. So that isn't the email trail that I'm talking about when I say he breached the code. That was not, in my opinion, a breach of the code. I'm not saying it is. The breach of the code arose from the other emails you sent to other councillors saying that you wanted to make a complaint about the clerk and copying them all into it, specifically the one on the 4th of March. So the original ones that you sent to the chair, I have not said that they amounted to a breach of the code.
Thank you, Simon. Yes, Tamir, continue. What's your next question, please?
So seriously, why would I keep continuing? Because you keep stopping me. I can't say anything. When I try to raise a point, you say no. So what's the point for me to keep asking the question? He raised the fact that I didn't follow the process. I tell him, I provide all the evidence that I follow the process. I sent email to the chair to set up the disciplinary meeting. It didn't. Can I have some time to confer with my advisor, please?
It was about following the process for the investigation email. That's what the point we've been making, and keeping on track for the investigation.
Have time to confer, or if it's denied, record for the minutes that time for conferring with the support worker has been denied. Thank you.
How long do you wish to confer? So you've got 30 seconds remaining, so we are only coming back in for a short time.
5 minutes.
5 minutes to confer, and then how many minutes to continue? Because we're already at time. 3 minutes. 3 minutes to then continue because we are over time.
Chair, with due respect, I know that you kept telling Taimur that he should not be asking questions, and that doesn't seem a fair process. So I have concerns about what I've observed in terms of the procedure, how it's been conducted in this process.
Could I just say that at the beginning, I made it very clear what the questions were to be, and if the questions weren't on that line, I would be asked, could I speak, please? That I would be asking Tamir not to continue with that line of questioning. And that's
Tamir's time to ask questions. It is within his right. I just note my concerns about the procedure and how Chair has been putting pressure on Tamir not to ask questions that clearly the investigator feels uncomfortable with. So I want this to be recorded for the minutes.
I've just recorded for the minutes that Tamir is representing himself.
Yes,
you are here to ask.
She's my advisor, and she's allowed to speak on the.
She is not allowed to speak unless I allow her to speak, because you are asked to represent yourself.
Okay.
And that's what we're working with, is that Tamir is asked to represent himself.
Yes, he's representing himself. I just want to air concerns because it is beyond what I normally observe. So
It
I
isn't
might
your
that.
right to
Thank you.
make concerns, to observe and speak, as we've already agreed with Tamir that he is representing himself. You are able to speak with Tamir, like you're going to have a little space to speak now, but you are not
Chair,
entitled
can you have this
to
3 minutes then?
You're not entitled to speak. I just want to be clear with that.
Okay,
That is
we
the
understand.
process that we're in.
Okay,
within
thank
this
you.
meeting.
Can you
Thank
have those 3 minutes then?
So you want to confer before you have the 3 minutes?
Yes, please.
Yeah,
Thank you.
5 minutes at the maximum for conferring.
Okay, thank you.
Chair, sorry, is it okay if I take a quick comfort break while they're conferring? Thank you.
Thank you, Tamir. If you would like to continue with your
Yes,
questions,
yes,
you've
I'm
got
happy to continue.
3
Thank you.
minutes.
Yeah.
Sian will time it on her phone as you can't start the.
Okay, thank you.
And if we could keep to you representing yourself in future.
Thank you.
And
Understood.
thank you.
Yeah, according to LGA, for bullying and respect matters, both parties should be investigated. Why the clerk hasn't been investigated?
Where does the LGA say that?
This is part of a local government, this is defined by the local government, by bullying and harassment.
Where does it say that? I'm not familiar with what you're quoting from or you're purporting to quote from.
So are you denying the LGA guidance then? Because that is part of the LGA guidance.
If you can show me where the LGA guidance says that, I'll comment on it. But I'm not aware of the LGA guidance saying that, and you haven't highlighted where you've got that from.
Right. Okay. Are you just denying the fact that if there is a matter of bullying, both parties need to be investigating? Can you just deny the fact that it's not true? So because I won't be able to find this straight, so I just want you to say whether it's true or not. If we have a bullying matter, both parties need to be investigating. You are saying no, it's not true.
The process is the member conduct process is that the council has to have arrangements in place for investigating allegations that a member has breached the code of conduct. So the council, the principal authority's legal responsibility is to investigate that complaint.
No, that's not my question. My question is it both parties need to be investigating, yes or no, based on the LGA? And you are a lawyer.
Well,
I'm asking you.
First of all, I don't believe you've highlighted any LGA guidance.
Oh, now you're shifting again. You're shifting. Can you just respond to my question?
Well,
I'm asking whether it's true both parties need to be investigating. Don't say to me that I didn't ask you whatever you want to say. Is it yes or no? Both parties need to be investigated. If it's yes, why the clerk hasn't been investigated? If it's no, fine. We're going to record it. You say no. That's just what I'm asking. Thank you.
As has been explained both by the chair and me several times, I have no remit over the clerk. The city council has no remit over the clerk. If there is an allegation that the clerk has been bullying, yes, that should be investigated by their employer, not by me, not by the city council.
Time is up. Thank you.
Thank you.
And we're going to move on to any members of the subcommittee or independent person have questions they would like to ask at this stage. Aisha.
Tamir, you raised the question about bullying and harassment. If you've been bullied or harassed, have you reported that? You raised it about the clerk.
No, that wasn't me who raised the question of bullying. That was in his report talking about bullying the clerk.
Right.
And then I said, if is that the case, why both parties hasn't been investigating? I was investigating because apparently I'm the one bullying the clerk. But why the clerk hasn't been investigating? Why I'm the only one who's been investigating? Because I got so many evidence, I shared so many email where the clerk has been like denied me the training or stopped me to access my own email. So what is it?
Okay.
He knows about that. But at any point, he went through it, why our email has been suspended, why has been denied to follow the training, why the class has been constantly interrupting me. So nothing of that has been highlighted in his report.
To me, I'd just like you to bring you to paragraph 2.2 of the code. I do not bully any person. And the investigator's findings are Mr. Fuller is robust and able to respond fully to Tamer. Some of the exchanges were initiated by Mr. Fuller and he frequently interrupts Councillor Puti in meetings, but this breach has not been found. That hasn't been proven by the investigator. So I don't know what your point you're trying to make, because this isn't a breach. You haven't been breached for bullying. That is not part of this complaint.
Yeah, but Chair, what I'm asking is why do Clark hasn't been investigating? Because on the matter of bullying and harassment, why am I the only one who's been investigating?
Because I haven't had the standards committee, the monitoring officer hasn't received a complaint about Clark. And that, yes, sorry.
Sorry, so this was what I was explaining before. So what's happening here is as a result of a code of conduct complaint that's been made against you, Tamir. And the process for making a complaint against a clerk is a different one, separate to this hearing. So no one here, the City Council as a principal authority has absolutely no jurisdiction over a parish council employee, which is what the clerk is. There's separate procedures for that, which will be set out in the parish council's procedures in line with employment of their officers. So neither Simon nor anyone here can actually answer the question about why a disciplinary has not been started against the clerk.
I'm not asking that. That's not my question. My question is, if there is the matter of bullying in place that highlighted by, the paragraph 211, consider whether there were any other breach of conduct, and in particular whether there was bullying or harassment of him by Mr. Fuller. In my view, there was not. In reaching that view, I consider that the action of both parties relevant law and guidance in the exchanges between the two. It's clear that Mr. Fuller is robust, that's what you just said, Sharon, and able to respond fully to Councillor Bungopachi. Some of the exchanges are initiated by Mr. Fuller, and he frequently interrupted Councillor Bungopachi in a meeting. Therefore, I don't believe that Councillor Bungopachi can be said to be bullying or harassing Mr. Fuller. Based on this, what I just read, why Mr. Fuller hasn't been investigating fully? Why it's just on me?
Not sure how else I can explain this, but I'm going to try again. You have been investigated because that is part of a code of conduct process which allows complaints to be put in against councillors, and then it is the responsibility of Milton Keynes City Council to process those complaints. So that's what we're here for today. You're asking, why has a clerk not been disciplined? That is not a matter that is before us today, nor is it a matter that we can have any comment on. And it was not part of as a result, it did not form part of the investigation brief.
Sharon, I didn't ask why the clerk hasn't been disciplined. I didn't ask that. I asked why he hasn't been investigating, which is different.
Okay, sorry, that's a slip. Okay, let me clarify. Any actions in relation to the clerk are matters for the parish council.
Any further questions from the subcommittee or the independent person at this stage, please? Yes, Chris.
Thank you, Chair. Can I point out that this hearing has as a finding of fact found that your behaviour at certain times has been described as aggressive, hostile, bullying, etc. Are you saying that you believe that that behaviour was not hostile, aggressive, or bullying? Is that what you're saying?
That's correct, Mr. Chris.
Thank you, Chris. Any further questions, Selina?
Chair, can I ask or the independent person his view on whether the code has been breached, please?
Oh, there is an opportunity. Thank you. Then you will come back to that. So now we will hear from the subject member on whether the code of conduct has been breached. Please could you make your representations, including hearing from any witnesses with evidence relevant to whether the code of conduct has been breached.
Thanks, Chair. So what I'm trying to express here is I was first in a situation where I just stand to my ground because I really found that the way the payroll bidding went through, I thought it was really unjust, no right for a councillor to be bidding for the service payroll. This is the whole picture I need to point out. The financial regulation wasn't followed, and my question was dismissed earlier because by the investigator, the clerk wouldn't get into debate with a councillor and walk out of the meeting. The clerk couldn't have made any delegation decision based on our financial regulation, and the investigation conclusion that what the clerk did was okay. It's not right because the clerk, we did ask the clerk to seek for advice. Instead of seeking advice, the clerk was giving advice to the advisor to, like I showed earlier during the, I asked you to read a couple of 3 pages. And this is a public interest matter. And what I did was just to prevent that unfair process to be followed. I'll stand to my ground and I will do so if that's going to happen again. So I will not let any unfair process to be done in under my watch. And I want this to be recorded again. I still believe that the investigator was biased in his investigation because he dismissed a couple of things. He didn't look at the financial regulation. He didn't look at the clerk behavior. It didn't look at why the anonymization procedure was admitted by the clerk. So all these facts, I think that the investigation was biased. It didn't look at all that. That's what I would say. Thank you, Chair.
Thank you. Simon, do you have any questions for the subject member at this stage?
No.
No. Do any members of the subcommittee or the independent person have any questions at this stage? No. Yes, Selina.
Just for clarification, a yes or no answer. Do you feel there has been a breach of code?
No.
Thank you all. I will now ask the investigating officer to sum up the main points of the argument relating to whether the code has been breached only, please.
I don't think there's really much I need to add. I think you've heard all the points that I've got to make. I think what is being raised is not relevant to the considerations you have to decide. The arguments about the financial regulations weren't actually ones that were being made at the meeting. The argument was about anonymisation and whether or not it was appropriate to proceed without that. So they are being, to the extent that they are a justification, they're being used as a justification after the event in any case, and they wouldn't be a justification for the behaviour even if they were the issue that was being discussed at the meeting. The other point I would just like to highlight is there are ample instances. The comment about corruption in Africa. If you've not listened to it, it was suggested that was at a time when the chair was trying to close the debate down. It wasn't. It was actually at the end of the meeting, right at the very end of the recording of that meeting, if you wanted to listen to it. And it was made as people in the room after the meeting had effectively finished were having a discussion about that item. So the suggestion that it wasn't a commentary about the position in the council or that particular contract, in my view, lacks any credibility or realism. It just to make a throwaway comment about corruption when you've heard the subject member say he thinks it's a matter of public interest, and he would say the same again. To say it was unconnected or just a comment about Africa because that's where he's from, it just has no, I think, credibility whatsoever, and was clearly a comment about his views on that particular contract because that was what was being discussed and that was what he'd been so animated about. It isn't about members being able to challenge things they don't agree with. Members should do that. It's their obligation, it's their duty, but that can be done in a respectful way and it can be done within the rules, and that's what the issue is here. It's the way it was done, how it was done, the forcefulness of it being done, the inappropriateness of the language. That's what amounts to a breach of the code, not that members can't challenge other councillors or officers of the council. They can and should, but they should do it in a respectful way. So I've got nothing further to add.
Thank you. And now, Tamir, if you could sum up the main points of your argument relating to whether the code has been breached, please.
Chair, all I would say is because it's a public interest matter, all I did is try to make sure to prevent any unlawful procedure. That's it.
Thank you. Thank you, members. And before we adjourn again, to consider the representations, please can I ask our independent person to give their views to the subcommittee as to whether the code has been breached.
Thank you, Chair. I'll turn first of all to the question of failing to declare his work with Tesco. That is a clear breach, in my view, of the failure to declare, which is part of the Code of Conduct. The evidence is very stark. It was clearly a deliberate act when he wrote none in the appropriate box. And also, of course, as pointed out by the investigator, the SM knew that he had previously declared working for Tesco. So that is definitely a breach of the code, in my view. Moving to the behaviour side of things, both towards the clerk and generally at meetings. We've heard today about the oral evidence, the tapes that were played, and I'm sure that we've all listened to them before, and also been reminded of the written communications regarding this, where the SM talked over the people who were speaking at meetings, used unprofessional language, interrupted, and even shouted over at proceedings. To the man or woman, person in the street, any such behaviour at council meetings would be unacceptable, would be behaviour which is not only disrespectful, but it's aggressive, it's hostile, and therefore breaches the code in a number of areas, I would suggest. Not treating others with respect would be one area, bullying and harassing others would be another area. And of course, the effect of all of this is to the person in the street viewing councils with some scepticism with regard to the conduct of business. And therefore, I think that the panel should seriously consider whether this behaviour hasn't brought the parish council, in this case, into disrepute. For the person in the street to view this behaviour, it is of such magnitude that that must be a consideration. And those are my views on breaching the code, Chair. Thank you.
Thank you, Chris. And now, so we've asked the, done here. So the subcommittee will now retire again to consider the representations and evidence in private before making a determination on whether the code of conduct has been breached on the balance of probability based on the evidence that has been received at the hearing. As part of this, the subcommittee may at any time return to the main hearing room in order to seek additional evidence from the investigator, the subject member or a witness, or to seek legal advice from or on behalf of the legal advisor. If the subcommittee decides the code has not been breached, it will inform the subject member, and the subcommittee will then consider recommendations to the council. If, however, the subcommittee decides there has been a breach of the code of conduct, then we will need to move to the third stage, considering the sanctions. Thank you. So we'll move to another room now. Lunch.
Yeah, sorry, maybe if I'd waited, you would have answered my question for me. I was just going to ask about my continued involvement in the hearing. And I know obviously if you need me, that's absolutely fine. But sometimes at this point, given that you've got your deliberations and you've heard from me, the investigating officer sort of is no longer needed. I know in the letter it did talk about me making representations on sanctions should you find there to be a breach of the code. Albeit I have to say, generally, I think that's a matter for you, not for me. And I think in your hearings procedure, it doesn't actually allow that step in the process. So I suppose what I'm asking is whether I can be excused, if not now, at some stage, because I don't think I have anything further to add to the process. But obviously, if you think I do or might do, then I'm in your hands. But I'm also do have quite a long journey and one eye on the traffic on a Friday afternoon. Full disclosure. But obviously that's my problem, not yours. But if I'm not going to need to be making any further contribution, I'd be happy to be excused sooner rather than later.
Thank you, Simon. On conferring with advice, we are able to allow you to leave the process. And if we have any questions whilst we're deliberating, we can call you if that's okay with you. Thank you. And thank you very much for the part you've played in the hearing today. Thank you. Lunch. We need to discuss whether there's a lunch break now. So to include a lunch break in the deliberations, we'll now break for half an hour. So we'll be back at 2 o'clock, please. Thank you. Thank you all for your patience. We have now completed our deliberations on whether the code has been breached. And our determination is that we consider representations that the subject member's conduct was simply in line with raising public interest concerns about a procurement exercise. We also considered the argument that the clerk had been robust in his communication with the subject member. However, the subcommittee's decision is that the following paragraphs of the Kents Hill Monkston Councillor Code of Conduct have been breached. Paragraph 1.1 of the code: I treat other councillors and members of the public with respect. Paragraph 1.2 of the code: I treat council employees and representatives of partner organisations and those volunteering for the council with respect and respect the role that they play. Paragraph 5.1 of the code, I do not bring my role or the parish council into disrepute. Paragraph 9.1 of the code, I register and disclose my interests. So those are the paragraphs that we believe have been breached. So as it's now been determined there has been a breach of the code of conduct by the subject member, we now move to consider sanctions. The sanctions that are available to the panel are set out at the Appendix 3 of the Standards Committee hearing procedure, page 660 in the agenda pack. Now, as we've done previously, we will hear from the subject member on whether the subcommittee should apply a sanction and what form that sanction should take. Please could you make your representation, including hearing from any character witnesses you wish to call.
Thanks, Chair. Can I just ask, having been told that the independent person will be changed,
Sorry,
the independent person we had on the document was John Jones, and then now all of a sudden we have a different person.
John Jones.
Yeah. Why that has been changed all of a sudden, and no heads up have been given to the subject member in order to get in touch with that person. So
Tamer Sharma will answer that.
Thank you, Chair. So just for clarity, the document that you're referring to is the initial decision notice. At that stage, the independent person who gave their advice at that part of the process was Mr. John Jones. In a hearing stage, in order to have the advice from an independent person, we could have chosen to use Mr. John Jones again. There is no obligation that it must be him. And in terms of having an additional independent person, that is an additional independent voice that has considered the matter and has given their representation. So I think that makes it quite a robust process.
Sean, I did raise that question to you, asking whether it was possible for me to reach out with the independent person. You say that was okay, but what I don't understand, I did send you a question to ask if it's possible for me to reach out the independent person. You say yes, but if you change that independent person, that you think that it was fair for me to know that you're going to have a different independent person.
The question that you asked was, can you have their contact details in advance of the hearing?
Yeah.
That wouldn't be appropriate because the independent person is here to advise the panel, not yourself. So the independent person must be kept independent. So you were provided with his biography. At that stage, we did tell you the name of the independent person and his biography, but we didn't provide his contact details because that wouldn't be appropriate.
Did you have any advice for John Jones regarding this case?
So before we moved to the hearing, we did reach out to Mr. John Jones. His feeling was that it should move into a hearing stage of the process.
Right. Okay. So I still don't understand why I've been informed about Mr. Chris Fogden as an independent person attending the meeting. So I just think that wouldn't be fair for me to be aware. That's fine. So I don't want to argue about that.
No, but we did inform you that it was Mr. Fogden. Yes,
absolutely
we did.
no.
If necessary, I can provide the email in which I informed that it was Mr. Fogden that would be in attendance.
That's fine. Thank you. So yeah, Chair.
Sharon would like to speak.
Yeah, just to clarify that before today's proceedings, not only did Sean tell you that it was Chris, but she provided you, as she's just said, with his biography committee. I think you should be aware of that, with his biography. The hearing procedure. Sorry.
Sharon, so I was just listening to what she was telling me.
I was clarifying that prior to today's hearing that you were provided with Chris's name and we also provided you with a bio for Chris.
Thank you, Sharon. Emma, would you like to continue now?
Yes,
Your
please.
time is quickly running down. Emma, could you speak? And
Sorry.
what would you like time to confer?
Yeah, can I have
Why do you
time
need time to confer?
Because I just need to respond to Sharon and Sian about the independent person, please.
Can you tell me what the relevance of this point is? The independent person is here to advise the panel. It's not here to advise you. It's here, Tamer. Excuse me.
Because on the page 15, Mr. John Jones did recognize that there was no breach of conduct, breach of code. That's the reason why I just tried to find out why all of a sudden Mr. John Jones has been kept, and then I wasn't being informed about Mr. Chris Fogden. That I just find this quite confusing. Thanks, Chair.
So page 15, you're saying?
On page 15
of the pack.
On page 15, 6.1, it says, including alleged behavior at a meeting of 11 March, did not breach the code. That's not me, that's you guys. Thank you.
I can't find it. It's not on page 15. Which is page 15? We're looking for you.
Okay, this is to do with the
Yeah.
to do with the separate.
If I may read over it, as required by monitor officers, as taken into account the view of the independent person in this matter. The independent person view is that the failure of property registers in interest among investor as a director and shareholder is likely to constitute a technical breach of conduct, but that the remaining allegation, including alleged behavior at the meeting of the 11th of March 2025, did not breach the code. Thank you.
Chair, if it's helpful, the council has appointed a bank of independent persons, one of which is Chris Fogden. In fact, we are considering 2 code of conduct complaints that were grouped for the sake of this investigation. When at any point a code of conduct complaint comes in, it is allocated to an independent person, and their role at that point is to provide an opinion to the monitoring officer about the next steps. You can see in one of the decision notices in respect of one of the complaints, the allocated independent person was of the view that there was a technical breach, but not a breach in respect of the other clauses of the complaint. We're at a point in the process now where we've grouped 2 complaints, and our arrangements and our hearings procedure requires that an independent person is present. It doesn't have to be the same independent person. And in fact, 2 different independent persons gave an opinion to the monitoring officer on these 2 complaints that were then grouped for the purpose of investigation. So that's Chris's role today. He is an independent person that was correctly appointed by the council. He's here at the hearing to fulfil a role that's required by both our arrangements and our hearings procedure.
Chair, it's just the feeling I've got that I've been targeting because John Jones said that there was no breach of conduct on 11 March 2024, and all of a sudden his all disappear, is no longer available. Right. And now we got someone else. We say that clearly there was a breach of conduct.
We are looking at 2 complaints which have been gathered together. So what you're looking at is referring to one of the complaints. The process then was the 2 complaints that came in against you from the chair and the clerk were then grouped together, and the process went forward from there. So there's been a whole process.
Yeah, still, Chair, I really think I've been targeting and the investigator has been biased. So John Jones has been all of a sudden Asia disappear, and then the monitor officer didn't inform me about the appointment of the new independent person, which is quite bizarre. I asked whether I was able to reach out this person. I've been told, yeah, at some point, yes. And yeah, it's just my feeling.
Okay, Chair,
Thank
if
you.
I, just as a matter of legality, as a matter of fact, you were informed of Chris's attendance. But secondly, as a matter of legality, as the name suggests, an independent person is independent of the council. So to suggest that change an independent person would yield a result that someone is looking for undermines the word independent. So I think maybe we can put this to rest if Chris allows me to ask him a question. Tamir, I think, yeah.
Sorry, Sharon. Yeah, I'm listening, don't worry.
You were just given time to confer, but you chose to. The chair had just given you time to confer, and then Tamir's. Sorry,
And the chair.
This is not a back and forth.
I'm sorry that Tamir agreed to represent himself. So
Procedural concerns because
yes, you can speak to him quietly, but you can't speak aloud. That isn't the role that you have in this hearing. That isn't the role that you have in this hearing.
So
and you can be asked to leave if you continue. Yeah. So as we said earlier, if you're not following the procedure, we can ask you to leave. This is the last opportunity.
The whole meeting is being recorded and the minutes will be made on the basis of the recording of the meeting.
Okay, thank you.
You are here at my permission as a support for Tamir, not to represent him. He has agreed to represent himself. So I am in the position to be able to ask you to leave. I've given you a warning now. And if it comes to that question again, the subcommittee will vote on that and you'll be asked to leave. So please have your conferring with Tamir quietly under the table, whatever you want, but not speak to the committee. I don't give permission for that.
Chair, can I just...
Sharon is going to continue. She was in the middle of
before Sharon follow up, we did ask to have some time to confer, and the chair, you didn't allow us to have time to confer.
I did not allow you. Went on to question things, so
okay.
We are allowing the conferring.
Yeah, the chair did allow time to confer. It was
no,
you. It was you, Tamir, that spoke during that time. But for clarity, I'm sure once I'm finished dealing with the independent person's point, then the chair will consider giving you time to confer. I just wanted to ask Chris whether before coming to this hearing today, he was asked to share his opinion or give any indication of his position on this matter.
I can clearly state that I was not asked for my opinion. In fact, if I had been asked for my opinion, I wouldn't have come because I am an independent person. My view of what takes place over 25 years of standards organisations is that you get a complaint coming in and an initial assessment is made by an independent person. I believe that they choose on a taxi cab principle. So that means the one that's done it last time goes to the bottom of the queue and they pick one at the top. So they spread the workload amongst the independent people. I get then a document for which I make an initial assessment. And in this case, it wasn't me. It was John Jones, I think is the name you're dealing with. At that stage, it then goes through a whole nother process and you end up with a hearing, if it's not resolved, with all the evidence. And you come here with all of that information and you listen to the person making the case for why they did not do what they are accused of doing. And to have a different independent person seems to me to be a jolly good idea, apart from the fact it's not a requirement that the initial person goes to the hearing. It's not a requirement in law.
Do you recognise?
Thank you, Chris. We're going to leave that there. And Tamir, you've asked for a 2-minute to confer, so please take your 2 minutes to confer. No. That's 2 minutes. Thank you, Tamer.
Yeah, I'm ready, Chair.
So we are starting it. We're not sure how many minutes you've had, so we're going to start from the 10 minutes again.
Okay, thank you. First of all, I would like to ask a question to Chris here. Do you recognize that someone may have a different opinion on the way you see things? Because we both wearing glasses.
Sorry, Tamir, process. We need to stick with the process. So the process is at this stage that we will hear from the subject member on whether the subcommittee should apply a sanction and what form any sanction should take. And please, could you make your representation, including any witnesses? It's not an opportunity for you to ask the independent person questions. It's purely your comment on the sanctions. We've already made a decision on the sanctions, on the breach of code. We are now looking at the sanctions and you are able to give your view on the sanctions.
What I don't understand, if the monitor officer has been given advice that there was no breach of a conduct, why are you still going ahead?
We have had a whole process since then. As you've heard, that was right at the beginning when the initial complaint came in at the initial
you asked me the
stage.
question. You asked me the question about whatever.
There are 2 decision notices. One refers to the first complaint, one to the second complaint. So you're picking one element, and then we've had a whole process.
I didn't pick John Jones. That's not on me. John Jones gave you a advice that there was no breach of conduct, but are you still going ahead because you determined to find out I breached a code of conduct, but are you still going ahead? That's why I don't understand. Why are you still pushing things? Why you keep pushing things? If you have your own opinion from an independent person saying that there was no breach of conduct, why the monitor officer didn't take it on the board and say, yes, there's no breach of a conduct? This what's happening behind. So there's an agenda. Well,
So just for clarity here, there were two complaints, 2 decision notices, 2 independent persons. So if you look at page 9 of your pack, there's also a decision notice from Deborah Maggs, who is a different one of our independent persons, in which she gives the opinion that there has been a breach of the code of conduct. In any event, it is the monitoring officer who makes the determination. What the independent person provides is advice. So their advice is not legally binding on us if they say there isn't a breach. If the monitoring officer is of the opinion that there has been a breach, we can still go ahead at that stage. But just to be clear, a different independent person to the one that you are quoting has provided a decision notice in which they say there has been a breach of the code of conduct. And that is why we are carrying on with the process.
To me,
Chair.
can continue.
Yeah, Chair, I would, before I carry on, I will request for a copy of this meeting. Obviously, as Ian said at the end, I'm probably going to have a copy of this whole meeting, is it? Yeah, that's what I'm saying. Yeah. Okay. Yeah, I will. Yeah, I would love to have a copy of this. And then your question was whether I think that I breach the code of conduct. I just said.
We're asking you now to comment on whether we should apply a sanction and what form that sanction should
Yeah,
be.
but to apply
That's
the
what we're
sanction, I need to recognize that I breach the code of conduct, is it?
That has been decided by the committee, so you don't have any further comment on that.
Well, in that case, I don't have any comment then. So
Thank you.
But I just stand to my ground. So if
Thank you. So do any members of the subcommittee or the independent person have any questions they would like to ask at this stage?
Sean, am I going to have an independent copy?
Sorry, we're just asking whether the independent person has a question. No, of you. Thank you. Does that come afterwards? So we'll come back to the view once the subject member has summed up. So Tamia, do you need a couple of minutes to sum up now on the sanctions?
That's really nice. Thank you.
Thank you. We can't hear you. Sorry.
Oh, I thought you giving me the time to sum up.
Yes, I'm asking you to if you need to sum up now.
No, now.
Now, yes.
No, I don't. That's fine. I'm not
That's
summing
fine.
up anything. Thank you.
Thank you. Thank you, members. Before we adjourn again to consider the representations, please can I ask our independent person to give their views to the subcommittee as to appropriate sanctions.
Thank you, Chair. I noticed that the investigator touched on this subject, and I have always held the same view that it's always a little difficult at this stage for the independent person to say what the sanctions could be. I think it's a reasonable thing to offer the opportunity, but I have never accepted it fully because I find it's a little difficult situation at this time, and it really is up to the panel to decide on the sanctions. But there is just 2 things that I would add, and just 2 small reminders. The first is I'm sure you'll take into account all the aggravating features and any mitigating features that you have identified as well. But secondly, if part of your deliberation is going to be an apology that's got to be issued, then I think that should be carefully monitored and worded, because apologies can very easily slip by that become qualified. And I think that is something that has to be avoided, particularly in this case. And that the person making the apology should spell out precisely what they are apologizing for. And there should be timescales to this apology. It should be by a reasonable time that that the panel would decide, and someone needs to review the draft before it goes out to meet those reasonable criteria. I guess there might be a few more criteria, but nevertheless, that's all I would say at this stage. And thank you for the opportunity, Chair.
Thank you. And the subcommittee will now retire to consider the representations and make a determination on whether the subcommittee should apply a sanction, and if so, what form this sanction will take. As part of this subcommittee, we'll also consider whether to make any recommendations to the authority with a view to promoting high standards of conduct among councillors. And the subcommittee may return at any point to the main hearing room in order to seek additional advice. And we will aim to return within 10 minutes to the room. So we will be back in 10 minutes, maybe longer. Thank you. More for your patience. We have now completed our deliberations, and our determination is that the subcommittee considered the investigator's report, and specifically paragraphs 199 to 202. The subject member made no representations on sanctions, including factors to be taken into account or mitigation, as he did not accept that he had breached the code of conduct. The committee took the following factors into account: the subject member's intention to advance the public interest in decision making, the subject member's assertion that the clerk had tried to prevent him participating during the debate. The committee considered the following aggravating factors: seeking to unfairly blame others, paragraph 9.1 of the code, I register and disclose my interests, and continuing to deny the facts despite clear contrary evidence, paragraph 1.1 of the code, I treat other councillors and members of the public with respect, paragraph 1.2 of the code, I treat council employees and representatives of partner organisations and those volunteering for the council with respect, and respect the role they play. Paragraph 5.1 of the code, I do not bring my role or the parish council into disrepute. Paragraph 9.1 of the code, I register and disclose my interests. So the subcommittee makes the following recommendations to Kents Hill and Monkston Park Parish Council. 1, that the subject member be censured. 2, the subject member submit a written apology that is published on Kents Hill and Monkston Parish Council website within 28 days of its resolution, which adequately addresses the breaches of the Code of Conduct, words to be agreed by the monitoring officer and parish council chair, made to the two complainants and councillors and residents of Kents Hill and Monkston. Number 3, the subject member undertakes such training in relation to registering and declaring interest, council officer relations, including the role of the clerk, role of the councillor and the code of conduct. And number 4, that the monitoring officer asks the parish council to report back to the monitoring officer within 3 months. And finally, the committee notes that all code of conduct complaints should be resolved informally where possible, and the opportunity to do that at various stages, including after the investigator's report, were declined by the subject member. For the record, the indicative direct costs of the process to date are in excess of £7,000, and the subcommittee asked the monitoring officer to prepare a report on the finalised costs for this matter for the next meeting of the Standards Committee. Thank you. And I thank everyone that's been here today supporting this process. And we have, this is the end of the meeting. I think there was a page on the end, wasn't there? Sorry. Yeah, so am I here now? Yeah, that one. So this brings us to the end of today's subcommittee meeting. Can I thank everyone present for their contributions to the conduct of the hearing process and close the meeting at 15:25. A short written decision will be agreed by the subcommittee as we've just read out and made available today. Within 2 weeks of this hearing, we will agree a formal written notice of the subcommittee's determination, and the monitoring officer will arrange for its publication. Thank you, everyone.
Can I have a word, Chair?
Sorry?
Can I ask something before you close?
No, we have finished now. That is the closure of the meeting. Yeah. Can you ask? You can speak to Sharon after, but that is the formal end of the meeting, I'm afraid.
But for the purpose of this meeting as well, obviously you close there. I just need to let you know that I was going to appeal this decision. And for the purpose of that, I would like to receive an editing copy of this meeting. That's
You
what I'm
will,
asking.
the recording of the meeting will be
Yeah,
put up on the
and editing
YouTube.
one, and redacting and editing one.
On YouTube. It will be put up on YouTube.
Okay,
Yeah.
thank you.
Thank you.
Does ever occur is to take out the long gaps within the adjournments because it's just footage of an empty room.
Yeah. That's fine. We've heard the request and we will comply with it. It'll be up in YouTube in time.